Okay, Your Honor, we are now live streaming and you may proceed when ready.
Great, thank you. All right, welcome everybody. Good afternoon. Court will call the People v. Avery Becker. So I understand this is being live streamed, and I imagine the teams are familiar with how that is working and everything, and there's no issues with that. I guess I should start by asking if the parties are ready to proceed for the People. And Mr. Dujic, are you representing the prosecution or the defense in this case?
You're on to the defense.
Okay. For the prosecution, if you could just let me know you are ready to proceed or not.
We are ready to proceed, Your Honor.
All right. And is the defense ready to proceed as well?
Yes, Your Honor.
Okay. Just a reminder, there'll be no recesses will be allowed, with the exception of if there's a health emergency or something like that. And we previously had completed conflict checks with the scoring panelists who did not indicate that there were any reasons to be biased in judging either team. Any disputes arising out of this competition must be reported in accordance with the competition rules. The compliance with the time requirements will be considered in scoring individual performances. So at this time, I would ask the prosecution to introduce its attorneys as well as the witnesses it will be calling.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Helen Blake, and today I will be conducting the direct examination of Kyle Cusack and the cross-examination of Blake Van Owen. Your Honor, permission for my co-counsel to introduce themselves?
Granted.
Thank you, Your Honor.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Bo Turnage, and today I will be providing the direct examination of Jordan Markowitz, the cross-examination of Avery Becker, and the prosecution's.
Members of the jury and opposing counsel. My name is Jane Lockley, and today I will be performing the opening statement, the direct examination of Alex Cifuentes, and the cross-examination of Taylor Perkins.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Ellie Wadsworth, and today I will be Jordan Markowitz.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Audrey Gordon, and today I am Kyle Cusack.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Mary Walker, and today I am Alex Cifuentes.
Great, thank you. And I'll have the defense introduce themselves in just one moment, but I would also ask the scoring panelists if you could please stop your video. I think that helps with bandwidth if we only have the participants on camera until the end. Thank you. All right, and for the defense, go ahead, please.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Michael Dudzik, and today, along with my co-counsel, we represent the defendant, Ms. Avery Becker. Today, I will be conducting the direct examination of Blake Van Owen, the cross-examination of Kyle Cusack, as well as delivering the closing argument. Your Honor, may my co-counsel introduce themselves?
Yes.
Good afternoon, Your Honor. I'm Ella Damon. I will be delivering the opening statement. I will also be conducting the direct examination of Taylor Perkins and the cross-examination of Alex Fuentes.
Good afternoon. My name is Anna Seaman, and today I will be conducting the direct examination of Avery Becker and the cross-examination of Detective Markowitz. Permission for the witnesses to introduce themselves?
Yes.
Good afternoon. My name is Octavia Gomez, and I am Avery Becker.
Good afternoon. My name is Maisie Bogich, and I am Taylor Perkins.
Good afternoon. My name is Thomas Deneza, and I am Professor Blake Van Owen.
All right. So now, the court will swear in all the different participants, starting with the attorneys for both sides. So if you all could come on camera and raise your right hands. There you go. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? And, okay. Didn't hear anything. Would you mind all just unmuting and then just saying I do or yes?
Yes, Judge.
Yes, Your
All right. Thank you. So now the witnesses for both sides, same thing. If you could please raise your right hands and just go ahead and unmute yourself real quick. Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Now, if there are any gallery members, including teacher and attorney coaches, family members, and friends, if we have any of those folks, if you could please turn on your cameras. All right, seeing none. Scoring panelists, if you could please turn on your cameras and unmute yourselves and raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Thank you. All right. All right, so are there any other preliminary matters we need to address before beginning with opening statements for the prosecution?
Yes, Your Honor, the prosecution has several preliminary matters.
Okay.
First off, the prosecution requests permissions for our attorneys to either sit or stand during direct and cross-examinations, and we ask the same for defense.
Yes, that'll be granted for both sides.
Thank you, Your Honor. We also request that the witnesses be deemed to be on the stand when seated and appearing virtually on the Zoom screen, and we ask the same for defense.
Yes, they will be so deemed.
Thank you. We request that for the purposes of expediency, that any exhibits admitted to the court be deemed to be constructively have been permitted, or excuse me, published to the jury, and we ask the same for defense.
Yes, that'll be granted. So once an exhibit is admitted, both sides, you can go ahead and share a screen to publish it. You don't need to ask for permission to do so again.
And one final preliminary matter, we also ask the court's permission to deem any exhibit that is shared by means of screen sharing to have been constructively handed to opposing counsel for their review, and we ask the same for defense.
Yes, that will be done.
Thank you, Your Honor.
All right. And for the defense?
Briefly, Your Honor, the defense does ask, would like to confirm that any exhibits shared on the screen are constructively hidden from the jury's view until they are entered into evidence.
Correct.
Thank you. No further from the defense.
All right. there's nothing else, then the prosecution, you can begin with your opening statement.
Thank you, Your Honor. Ladies and gentlemen of the jury, on March 6th, 2020, the defendant, Avery Becker, was seen on Ring camera wearing a devil mask and entering the home of her mock trial coach, Mackenzie Brackman. Now, Avery had originally planned to enter the home of her coach that day and simply vandalize his property. However, what Avery didn't expect was that Brackman would be home that day, and that Brackman, aware of the attack on his home, armed himself against the intruder using a knife from his kitchen. Avery, shocked and panicked to see Brackman sitting in his kitchen, overtook him and gained control of the knife. The two struggled as Mackenzie Brackman fought for his life and Avery Becker fought to end their long-lasting conflict. Finally, near the front door, Avery stabbed Mr. Brackman in the back, quite literally. Avery proceeded to exit the house and left her mock trial coach dying, face down on the floor. The laws of physics don't allow an immovable object and an unstoppable force to coexist. One must eventually give way to the other. If there were laws governing the dynamics of high school mock trial, the same thing would be true. A team can't succeed if one person is an immovable object and another is an oppositional, unstoppable force. Here, a skilled public defender and beloved part-time mock trial coach, Mackenzie Brackman, was that immovable object. Brackman was a lawyer seeking to impart skills and motivate the next generation of would-be lawyers. But Brackman had his methods that led to success. Avery Becker, one of Brackman's more difficult mock trial students, was the unstoppable force. An irreverent young person with her own way of doing things, or rather, refusing to do things. Avery wanted no part of Mackenzie Brackman's preparation for trial, or even mock trial practices at all. Avery won awards, but was also demoted by Brackman for her unwillingness to be part of the team. Their dispute grew so heated that Avery vandalized Mr. Brackman's car. And then, Avery, fed up with her coach and seeking to regain what little pride she had left, went to Mr. Brackman's home to vandalize it too. Except, unfortunately for Avery, the immovable object, Mackenzie Brackman, happened to be home when Avery snuck in the back door. And before Avery Becker could leave, a physical altercation had broken out. That fight ended with a knife plunged in Mackenzie Brackman's back, and he died in a pool of blood in his front hallway because of an unstoppable force, Avery Becker. Today, the prosecution will call 3 witnesses to the stand. First, we will call Detective Jordan Markowitz, who will explain her findings on the crime scene, as well as the data collected from Avery's phone on the day of the crime, which proves through cell tower tracking that her phone was near Brackman's house on March 6th. Next, we will call Kyle Kuzak, a certified crime scene reconstruction investigator, who will describe to you the steps she took to reach her conclusion on the case. She will explain to you how the Ring camera footage from the day of the murder and the scuff marks in Brackman's home are evidence of a break-in and struggle that ultimately resulted in his murder. Finally, we will call Alex Cifuentes, who, previous to this crime, was great friends with Avery. Alex will relay to you the mutual loathing between Avery and Mr. Brackman. She will describe the level of disrespect and poor temper Avery had toward Mr. Brackman. Then, Alex will recall the night Avery vandalized Mr. Brackman's car. And finally, she will describe to you her texts with Avery, in which Avery explains her plan to break into Brackman's home. Members of the jury, the evidence the prosecution will provide today overwhelmingly leads to the conclusion that Avery Becker, the unstoppable force, grew fed up with her mock trial coach, and in her attempt to vandalize his home, Avery violently turned to murder. At the conclusion of this case, the prosecution asks that you find the defendant guilty of 2 counts, murder in the 1st degree and 2nd-degree burglary of a dwelling. Thank you.
Thank you, counsel. Defense, do you have an opening statement?
Yes, Your Honor. May it please the court. I'm Ella Damon, along with my co-counsel. We represent Ms. Avery Becker. The prosecution just told you this case is about the defendants acting obsession as an unstoppable force. It's not. It's about a careless and clumsy investigation by the Denver Police Department, making a mockery of justice. The victim, Mackenzie Brackman, coached a Colorado high school mock trial team. Mock trial is a pretend competition where students act as lawyers and witnesses, similar to what you will see today. But there are no consequences if you lose mock trial. No one's life is on the line in mock trial, like Avery Becker's is today. Avery Becker last year was a senior and was her 4th year on the team. She is talented and smart and had bright plans for her future. She would not jeopardize this future for an extracurricular activity. Coach Brackman and Miss Becker had a complicated relationship. They both needed each other to succeed in mock trial, but they didn't particularly like each other. You will hear about the constant criticism Coach Brackman dished Miss Becker in practice, but mock trial was easy for her. She was a natural, and Coach Brackman resented that. The evidence will show at last year's regional mock trial tournament, Miss Becker won 2 awards. Coach Brackman became even more irritated and said some horrible things to her. Miss Becker, who was still just a high school student, was upset. She took a marker and wrote on his car. A childish mistake, and she felt horrible about it. She apologized, but Coach Brackman wouldn't have it and threw her off the team. Now, although Miss Becker will tell you she was upset, she was not angry enough to murder her coach. She would throw away her entire future over mock trial. The evidence will show the night before Coach Brackman died, March 5th, 2020, Miss Becker and her best friend Taylor Perkins went to the Fry Shack. The next morning, Miss Becker will tell you how she realized she had lost her phone, so she and Miss Perkins skipped school that day and drove around looking for it. Miss Perkins will tell you she was with the defendant, Avery Becker, the entire day. Now, prosecution will claim to trace Miss Becker's location using cell phone geolocation data by pinging off various cell phone towers. But you will see a gaping hole in that evidence. First, cell phone data only shows where a cell phone is within a wide range, not the exact location of the phone. Second, the data only shows where a cell phone is within a wide radius, not who has possession of the cell phone. Miss Becker did not have her cell phone on her person March 6, 2020. Someone else must have. In addition to hearing from Ms. Perkins and Ms. Becker, you will hear from Professor Blake Van Owen, whose expertise is crime scene reconstruction, cell phone tower analysis, and police investigation. Professor Blake Van Owen will explain the prosecution's theory of Coach Brackman's murder is inconsistent with the evidence. Professor Blake Van Owen will explain how Kyle Cusack's photographs were conveniently corrupted. The victim is photographed without shoes, but somehow made scuff marks in an altercation with the perpetrator. The murder weapon is from a block of knives, but the identical handles of the block don't match the one that killed Coach Brackman. Now, Detective Markowitz will testify about how the investigation process was conducted, but listen carefully, because more important than what was done is what wasn't done. The prosecution just told you you will see text messages between Miss Becker and another mocker, Alex Cifuentes. But Detective Markowitz only received and relied on screenshots of these alleged texts instead of actually looking at the phone. Nor did Detective Markowitz look at or request phone data from Miss Perkins' phone to confirm Miss Becker's alibi. Miss Becker and Miss Perkins' phone data was simply ignored unless it appeared to the benefit of the prosecution. But the biggest mockery of justice, Professor Blake Van Owen will explain, is that Detective Markowitz zeroed in on one suspect, Avery Becker, from the get-go. She didn't entertain any other possible suspects, such as Blair Rollins, whose father's in jail because Coach Brackman lost his criminal trial. Miss Becker is charged with 2 crimes, first-degree murder and second-degree burglary. Because the prosecution has burden of proof, and it must prove every element of these charges beyond a reasonable doubt. The prosecution cannot meet its burden. At the close of evidence, you will see the only way to stop this mockery of justice is if you find Miss Becker not guilty.
Thank you, counsel. People may call their first witness.
Your Honor, the prosecution calls Detective Jordan Markowitz to the stand.
All right. You may proceed when you're ready.
Detective Markowitz, please introduce yourself to the jury.
Hello, my name is Detective Jordan Markowitz.
What is your profession?
I am a homicide detective with the Denver Police Department.
For how long have you been practicing in this field?
Well, I've been a detective for the past 7 years, but I've been working with the Denver Police Department for roughly 13 years.
Do you have any specialized skill sets in this field?
Yes, I have specialized training and experience with cell phones.
How are you trained to be able to use this skill set?
I had to complete a training course and pass a certification test through the American Academy of Law Enforcement. Through my training, I learned about the different types of cell phone data and records, how to use forensic data software such as Celebrite to download the information from cell phones, how to acquire and interpret cellular records as well as obtain and interpret cell records or cell tower data.
And how does this skill set help you with your investigations?
Well, I use this training constantly as a detective. I've had to interpret cell phone information in over 50 cases, and I've had to download the information from several phones, as well as I've obtained cell tower records in over 50 cases.
Your Honor, I tender Detective Jordan Markowitz as an expert in the field of crime scene investigation and forensic cell tower recovery.
Any objection?
No, Your Honor.
And the witness will be so admitted.
Detective Markowitz, how did you become involved in this case?
Yeah, so on March 6th of 2020, I got a phone call from first responders who found victim, Mackenzie Brackman, deceased just inside the residence at 444 South Flower Street. Officers and I secured the scene at approximately 2:20 p.m.
Explain your first observations when you arrived at the crime scene.
When I first got there, I saw that the front door was open, where I saw the victim laying face down in a pool of what appeared to be blood. There was a knife near his body and a stab wound on his upper shoulder.
Explain your first observations of the residence.
Well, I noticed that there was a ring camera on the outside of the house, so I walked around the outside through the unlatched side gate, where I found 2 more ring cameras. Then I walked through the unlocked back door into the residence, which appeared to be in a slight disarray. There was a knocked over chair and a broken plate. I also observed an open knife drawer of knives of different sizes and brands, as well as a knife block with an empty knife slot.
What was the opinion you first formed with this new information?
Based off the number of homicides I've investigated, it seemed fairly obvious that the victim caught someone breaking into the residence and armed himself with a knife from the kitchen. The intruder must have gotten a hold of the knife and stabbed the victim. The victim ran to the front door, either away from or after the intruder.
What was the next step you took in your investigation?
Well, as an experienced homicide detective, I never try to take the case where I think it should go. I follow the evidence and go where it takes me. So I downloaded the contents from Brackman's phone and watched the ring videos.
And you provided the police department with a copy of these videos, correct?
Yes.
Objection, Your Honor. Leading question.
Response, Your Honor.
Sure.
I'm simply laying a foundation for exhibits that are going to be admitted.
I'm going to overrule the objection.
Are the videos in the same condition today as they were when you first downloaded them?
Yes.
What did you do as the next step in your investigation? And what, apologies, I'll rephrase the question. What did you find when you downloaded the contents of Brackman's phone?
Well, what I first noticed was that there was just so many emails and text messages related to something called mock trial. I also noticed that the shirt Mackenzie Brackman had been found in was related to mock trial. So I decided to take my investigation towards mock trial, where I found out that Mackenzie Brackman was the coach of the high school mock trial team. And looking into the mock trial program gave me my preliminary suspect.
How did you find this suspect?
Well, I reached out to the Colorado high school mock trial team and got the contact information for all those students. When I talked to Alex Cifuentes, she told me about my lead suspect and defendant here today, Avery Becker.
How did you get this information from Cifuentes?
I conducted an interview with her and her family.
Did Cifuentes give you anything during the interview?
No, not during the interview, but she did give me something afterwards.
What did she give you?
She sent me screenshots of text messages between her and Avery Becker.
Did you obtain Becker's phone?
No.
Why not?
Well, it's the strangest thing. He actually claimed to have lost his phone the day before Mackenzie Brackman died.
Your Honor, permission to show the witness what has previously been marked as Exhibit 14.
You may.
Detective Markowitz, do you recognize this?
Yes.
Can you tell the jury what this is?
Those are the text messages between Alex Cifuentes and Avery Becker.
And is this a true and accurate representation of texts exchanged between Alex Cifuentes and Avery Becker?
Yes.
Your Honor, I move that Exhibit 14 be admitted to evidence.
Any objection?
Yes, Your Honor, on foundation and hearsay.
Response?
Your Honor, in response to the foundation objection, Detective Markowitz has clearly laid out that the texts were a crucial part of her investigation. And in response to the hearsay objection, under Rule 801D2, these texts are admissible because they were made by a party opponent, as well as 8033, they show a then existing state of mind as Avery Becker shows what she was planning to do.
Response, Your Honor.
Sure.
The foundation has not been laid that these texts are actually from Avery Becker. There's no timestamps within these text messages. There's no date. There are screenshots of the text messages, so we can't know for a fact that they are from Avery Becker. So therefore, the foundation has not been laid that it is an admission by a party opponent under Rule 801D2.
Response,
Right.
Your Honor.
No, that's all right. The court notes the objection, and I would agree that foundation would probably be more appropriate to be laid by the witness, Alex Fuentes. Given that, though, I find the rest of the objection goes to the weight rather than the admissibility of this exhibit. So I will overrule the objection and admit the exhibit.
Detective Markowitz, who sent the text shown in gray?
Avery Becker.
How do you know this?
Well, the contact name says Avery Becker, the first text, and Cifuentes told me that these text messages happened with Avery Becker.
What do Avery's first few texts show?
The first few texts show that Avery was pretty upset after being kicked off the mock trial team and was asking for help from Cifuentes to get back onto the team.
What do Avery's last texts show?
The last texts show Becker's plan to trash Brackman's house while he thought Brackman would be at work.
What did you do to further your investigation regarding Becker?
Like I said earlier, I tried to meet with Becker, but I was unable to. However, her attorney provided me with the phone number for Becker's phone, and I got a court order to obtain cell tower records from March 6th.
And what type of information are you able to find with cell tower records?
Well, technically what I received are call detail records, or CDRs. A CDR is the record created when you place or receive a call or text. Generally, the record shows things like the date and time of the communication, whether it was incoming or outgoing, the other number involved, and whether it was a text or call. Most importantly, the record shows which antenna and which cell tower the phone is connecting with and at what time. The phone usually connects to the nearest cell tower.
Your Honor, permission to show the witness what has previously been marked as Exhibit 16.
You may.
Detective Markowitz, do you recognize this?
Yes.
Can you tell the jury what this is?
That is a map of the cell towers Avery Becker's phone was connecting to on the day Mackenzie Brackman died. The map also includes the location of Becker and Brackman's house.
And is this a true and accurate representation of a map of cell towers near Mackenzie Brackman and Avery Becker's houses?
Yes.
Your Honor, I move that Exhibit 16 be admitted to evidence.
Any objection?
Yes, Your Honor. I have a few. I first object on hearsay and speculation and foundation.
Your response?
Your Honor. In response to the hearsay objection, 801A defines hearsay as a written statement or nonverbal conduct. This is neither of those. In response to the speculation objection, Detective Markowitz is an expert in cell tower and forensic cell data recovery and is thus qualified to be able to testify to the contents of this exhibit. And in response to the lack of foundation objection, Detective Markowitz just testified as to what kind of information she's able to gather from this exhibit and she is about to testify to how the exhibit helped her with her investigation.
You have any reply?
Yes, Your Honor. For the hearsay objection, you can see at the top that it says Becker's house, Rollins' house, as well as the bottom it says Brackman's house. Along with the line that has been made in dotted blue, this is a statement made by Detective Markowitz, a statement of where she thinks that Miss Becker took her phone on this route, an alleged route. And so it is a statement being used for the truth of the matter asserted. For the speculation, this route is not an actual route of where Miss Becker's phone took. It's a possible route. So to put this and enter it into evidence, it would be speculation to say that Miss Becker took this exact route, when in reality, Detective Markowitz as well believes that this is only a possible route. And the foundation has also not been laid that Detective Markowitz knows this area, knows the streets, and so it should not be entered because that foundation has not been laid that she would know what this map is of.
Okay.
Response, Your Honor.
No, I'm gonna sustain the objection as to foundation for the markings that counsel pointed out that are present on the exhibit. So for the people, I would ask you to attempt to lay some further foundation for those markings with the witness.
Yes, Your Honor. Detective Markowitz, have you used cell tower data in previous cases?
Yes, I'd say I've used it in over 50 cases.
And the line that you drew on the map, is that an exact line of the path that you knew Avery Becker took?
No, of course not. She could have taken any path, but I just thought that that would be the most reasonable path considering those are the main roads in that neighborhood.
Furthermore, are you familiar with the streets on this map based on the path that you drew?
I am. Yes.
Your Honor, I move that Exhibit 16 be admitted to evidence as additional foundation has now been laid.
May I respond, Your Honor?
Yeah, I assume you have an objection.
The foundation has, or Detective Markowitz just stated that this is a possible route, and there's a lot of other routes that Miss Becker could have, or Miss Becker allegedly could have taken on this date. So to put this into evidence as this being the route that Miss Becker took is speculation and is speculative. There is another map that doesn't have this route on it and doesn't speculate to the route that Miss Becker could have taken on this date.
Response, Your Honor.
No, that's all right. I'm going to overrule the objection at this time, and certainly the counsel's point can be made during cross-examination and argument.
Detective Markowitz, what can you see above each marked cell tower?
There are timestamps.
And can you explain what you drew on the map?
Yes, I drew a possible route that Becker could have taken from her house to Mr. Brackman's house. I drew this route based off where and when Miss Becker's phone was sending signals to the cell towers.
Detective Markowitz, what does the cell tower, what does the cell tower data indicate?
It indicates that Becker drove from her house to Brackman's house right before it took place.
Objection on speculation on saying that Miss Becker took this route when in reality these only show the route that her phone took.
Response, Your Honor.
Sure.
Seeing as Detective Markowitz is qualified as an expert in cell tower data recovery, she is qualified to make an opinion based on facts or data made available to her as per Rule 703. Furthermore, she is not saying that this path was definitively the route that Becker took, just that the data indicates that this was a possible route.
Right. I'm going to overrule the objection. You may proceed.
Please continue with your response, Detective Markowitz.
Yes, I was just saying that this is the route I thought Becker would have taken to get to her house, to Brackman's house, right before the murder took place.
Detective Markowitz, based on your 7 years of experience and 50 cases investigated, as well as the evidence you compiled at the crime scene and your expertise of cell tower records, have you formed an opinion on this case?
Yes, I have.
What is it?
My opinion is that Avery Becker entered Mackenzie Brackman's house and was surprised to find Brackman in his home. A fight then ensued, resulting in Becker gaining control of the knife and stabbing Brackman in his home.
Thank you, Your Honor. No further questions.
All right, cross-examination.
Yes, Your Honor. Now, Detective Markowitz, you took photos of the body at the crime scene, correct?
Yes, I did.
And please turn your attention to Exhibits 1 and 4. Are these fair and accurate depictions of the photos that you took?
Yes, those are.
Your Honor, I now move to enter Exhibits 1 and 4 into evidence.
Any objection?
No objections, Your Honor.
All right, exhibits, I'm sorry, did you say 1 through 4?
Just 1 and 4.
1 and 4 will be admitted.
Now, Detective Markowitz, please look at the Exhibit 4 on your screen. Mr. Brackman's right hand is to the right of his head, correct?
Yes.
Now, please turn your attention to Exhibit 1. His hand has moved to the top of his head, correct?
Correct.
Someone moved the body, didn't they?
I can't be sure what happened. The photos clearly show that his hand placement moved. However, I'm not sure what the cause of that was, but it is clear that Brackman is deceased.
You also took photos of blood splatter at the crime scene, correct?
Yes, I did.
And these photos were corrupted, weren't they?
They were.
So the defense never got to analyze them.
No, they did not.
You also stated that Alex Cifuentes gave you the biggest lead in this case.
She did. She told me about Avery Becker.
And she sent you alleged screenshots of their conversation.
Yes.
But you never reviewed the actual phone, did you?
No, she forgot her phone when she came to the interview with me.
So these screenshots only show what you received, not the actual text conversation.
Correct.
And so these screenshots could have been doctored, couldn't they have?
Objection. Question calls for speculation.
Overruled.
These text messages could have been doctored, couldn't they have?
I'm not sure. I don't know how people create false screenshots of text messages.
But they could have, yes or no?
I don't know.
You don't know because you never got the actual phone, did you?
No, like I said, she forgot it.
Now, you also reviewed CDR records, didn't you?
Yes,
And you reviewed Miss Becker's CDRs.
I did, yes.
But the CDRs only show where her phone is, not her location, don't they?
Correct.
So if Miss Becker didn't have her phone, these CDRs wouldn't show anything, would they?
That's true, but the claim that Becker lost her phone is quite odd, seeing that the phone is traveling around while looking for it. Or while
Exactly. Please turn your attention to Exhibit 16. To the left of Miss Becker's home says Rollins' house, doesn't it?
It does.
And so if Mr. Rollins had Miss Becker's phone, he would have taken the exact same route, wouldn't he have?
Yeah, he could have.
And Blair Rollins is a student at CHS, correct?
To my knowledge, yes.
And as an investigator, you thought that this murder could have been a disgruntled ex-client, didn't you?
That was my initial thought, but after further review, looking into Brackman's phone and seeing how much mock trial related stuff was in his life, I thought that the mock trial program would be a much more likely place for the suspect to have come from.
But you investigate every possible suspect, or you believe you should, correct?
Yes, but I try to go where the evidence takes me.
But you never investigated any former clients of Mr. Brackman, did you?
No.
And you never investigated Blair Rollins, did you?
No.
And you never investigated the relationship of Blair Rollins' father, Jonathan Rollins, to Mr. Brackman, did you?
No, I did not.
Now, are you aware of an audio recording involving Blair Rollins' father and Mr. Brackman?
It's not my witness statement. Would you like me to respond?
Yes.
Yeah, I am aware of it, I suppose.
Your Honor, I now move to enter Exhibit 22, which has been proven authentic under stipulated fact number 4 and is an audio recording from the trial of Mr. Brackman and Jonathan Rollins.
Any objection?
No objection, Your Honor.
I'll get you back, Brackman, if it's the last thing I do.
Someone is threatening Mr. Brackman in this recording, aren't they?
Yes, according to the audio.
But you never investigated this suspect, did you?
No.
No further questions, Your Honor.
All right, let me redirect examination.
Yes, Your Honor. Detective Markowitz, why didn't you investigate any other suspects?
Well, once I started to investigate Avery Becker, all the evidence pointed to her. I mean, she had recently been kicked off the mock trial team. According to the text with Cifuentes, she had a plan to vandalize and trash Brackman's house while she thought Brackman would be at work. And there's evidence linking Becker's phone to the vicinity of Brackman's house right before the murder took place. As an experienced investigator, there was no need for me to look into any other suspects. Becker had reason, means, and intention.
Objection, Your Honor. Detective Markowitz just testified to the ultimate issue and Ms. Becker's mindset, which is not admissible under Rule 703B.
Response?
Detective Markowitz was testifying to the defendant's state of mind, not Ms. Becker's, which makes the testimony admissible under Rule 704B.
Response, Your Honor?
Sure.
I believe that the defendant is Ms. Becker.
Apologies, Your Honor. I thought opposing counsel was referring to the statement where Detective Markowitz said that Mackenzie Brackman was surprised. Apologies.
No, I believe the objection is to what the witness was beginning to state about the motive, etc. Do you have a response to an objection as to that aspect of the witness?
I do. Detective Markowitz is qualified as an expert in crime scene investigation and has experience in investigating cases and is thus qualified to make an opinion about motive as she has experience in motives.
Response, Your Honor?
No, that's all right. It's a good objection. I'm going to overrule it at this time.
Detective Markowitz, please finish your response.
I was just going to say that with all my experience, there was no need to look at any other suspect, considering Becker had reason, means, and intention.
Thank you, Your Honor. No further questions.
The parties can hold on one moment. All right, thank you. You may step down and the people can call their next witness.
Your Honor, the prosecution calls Kyle Kuzak to the stand.
All right, you may proceed when you're ready.
Good afternoon, Ms. Kuzak.
Good afternoon.
Could you please introduce yourself to the jury?
Of course. Hello, everyone. My name is Kyle Kuzak, K-U-Z-A-K.
And what do you do, Ms. Kuzak?
Well, I am a crime scene reconstructionist, and I was certified by the Colorado Bureau of Investigation.
And Ms. Kuzak, what do you do as a crime scene reconstructionist?
Well, I normally investigate complex crime scenes, such as home invasions, homicides, domestic violence, fatal accidents, armed robberies, burglaries, and other property crimes.
And how long have you been investigating such crime scenes?
Well, I've been working as CSR for about 19 years now, and for the past 3 years of my tenure, I've been working with the City of Denver.
Thank you. Your Honor, I now tender Ms. Kuzak as an expert in the fields of crime scene reconstruction as well as crime scene investigation.
Any objection?
No objection, Your Honor.
All right, the witness will be so admitted.
Thank you, Your Honor. Ms. Kuzak, tell me a little bit about how you professionally approach crime scenes.
Of course. Well, I have 2 key principles that I normally follow, where first, I assume that every case is going to trial, so I conduct a thorough and comprehensive investigation, where second, I memorize, organize, and document all of the evidence with the mindset of future reconstruction. And with these 2 key principles in mind, they actually allow me to have a more accurate and efficient flow with my CSR work, which I approach in the form of 5 steps.
And could you tell me about those 5 steps?
Of course. Well, in short, these 5 steps are recognition and documentation, collection of evidence, evaluation of evidence, hypothesis and testing, and then finally reconstruction.
And could you go into a little bit more depth about those steps, please?
Of course. Well, for step 1, this is where I create a witness tracking sheet, a physical evidence tracking sheet, and a rudimentary flowchart and timeline, all of which so that I can see key physical and chronological relationships. And then for steps 2 and 3, this is where I prepare materials for formal analysis, And then I gather all of the evidence and place it into a spreadsheet so that I can see these chronological patterns better as well. And then for step 4, this is where all the evidence is then organized and then a hypothesis is developed. And then step 5 involves my CSR initial report, which then goes into peer review, resulting in a final CSR report.
And why do you approach crime scenes in this way?
Well, this way of approaching crime scenes allows me to have a more detailed and clear view of what exactly happened at the given crime scene.
Thank you, Ms. Kuzak. I'd like to move on to the crime scene at 444 South Flower Street from March 6, 2020. Tell me a little bit about the physical setup of this crime scene.
Of course. Well, while I was investigating the scene, the first thing that I noticed were the scuff marks that were immediately inside the back entrance. And then moving from that back door area to the kitchen, there was a broken plate on the floor, as well as an open knife drawer and a knife block with one empty slot. And then moving from this kitchen area to the front door, there was a blood trail, which led up to where Mr. Brackman had been found by the police. Additionally, I was also able to review all of the security footage showing a masked individual roaming around the residence prior to Mr. Brackman's death.
Could you tell me a little bit more about the security footage?
Yes, well, this security footage was taken from the Ring security camera system that was set up just outside of the residence, all of which pointing towards different entry points, such as the front door, the south side gate, as well as the back door.
Thank you, Ms. Kuzak. Your Honor, may I show Ms. Kuzak what has been previously marked as Exhibit 12?
You may.
Thank you. Ms. Kuzak, do you recognize this video?
Yes, I do.
Could you please tell the jury what this video is?
Yes, well, this is the third out of 4 videos that I was able to review. And in this particular video, it is showing the masked individual entering through the back door of the residence. And for this to have occurred, the individual would have had to move around the residence and enter through the south side gate in order to get to this back door.
And Ms. Kuzak, is this a true and accurate representation of this Ring video?
Yes, it is.
Your Honor, I now admit Exhibit 12 into evidence.
Any objection?
No objection, Your Honor.
All right, Exhibit 12, you said,
Yes.
will be admitted.
Thank you, Your Honor. Your Honor, may I now show Ms. Kuzak what has been previously admitted, marked as Exhibit 13?
You may.
Thank you, Your Honor. Timekeeper, do you mind pulling up Exhibit 13, please? Thank you. Ms. Kuzak, do you recognize this video?
Yes, I do.
Could you please tell the jury what this video is?
Of course. Well, this is the 4th and final video that I was able to review, this time showing the same masked individual now leaving the residence through the front door, escaping the scene.
And Ms. Kuzak, is this a true and accurate representation of this Ring video?
Yes, it is.
Your Honor, I now ask that Exhibit 13 be admitted into evidence.
Any objection?
No objection, Your Honor.
All right, Exhibit 13 will be so admitted.
Thank you, Your Honor. Ms. Kuzak, how, if at all, did these Ring videos play a role in how you came to a conclusion about this case?
Well, the individual in the videos, matching the general height and build of the defendant sitting here today, Avery Becker, was roaming around the residence, getting caught in all the security cameras, which were sending notifications to Mr. Brackman's phone, alerting him that there is motion happening outside of the house. And this would have given Mr. Brackman time to arm himself and prepare before this intruder would have then entered through the back door.
And Ms. Kuzak, what would have happened if Mr. Brackman didn't have his phone on him or his Ring notifications were turned off?
Well, if his Ring notifications were in fact turned off, he would have either at least heard the back door open as the intruder is entering, or would have heard the intruders shuffling around the kitchen area.
And Ms. Kuzak, what do you believe happened after the intruder entered the residence?
Well, I believe there to be a scuffle that immediately ensued right in the middle of the back entrance.
And could you tell me more about that scuffle?
Of course. Well, this struggle occurred immediately inside and to the right of the back entrance based on the scuff marks on the floor that I was able to review, which indicate that more than one person were in close contact there. And then this struggle would have then moved from this back door area to the kitchen, where the plate would have been knocked off the table and where Mr. Brackman would have been disarmed of his weapon and stabbed in the back of his upper left shoulder in a bear hug formation. Then this struggle would have continued to move from this kitchen area to the front door, where the knife would have then been removed from Mr. Brackman's back, resulting in immediate death by the front door.
And Ms. Kuzak, how did you come to this conclusion?
Well, I came to my conclusion based on the physical evidence, such as the blood droplets, the broken plate, the scuff marks, all of which that indicate that some sort of struggle occurred between the victim and the intruder prior to his death, and that this was no surprise attack of any kind.
Thank you, Ms. Kuzak. And one final question. In your 19 years of experience in investigating complex crime scenes, what are your final thoughts on this case?
Well, in the end, this was a planned burglary gone bad. The intruder clearly had knowledge of Mr. Brackman's residence and chose a day and time in which Mr. Brackman would have most likely been outside of the house. However, on this particular day, Mr. Brackman was in fact home, resulting in the struggle between the victim and the intruder, the disarming of the victim, and then resulting in the unfortunate death of Mr. Brackman.
Thank you, Your Honor. I have no further questions.
Thank you, counsel. Any cross-examination?
Yes, Your Honor.
Go ahead.
Ms. Cusack, as you just stated, you believe, I'd first like to talk about the events of March 6, 2020. As you stated, you believe that Mr. Brackman was made aware of this intruder from a Ring doorbell on his phone, the notification, right?
Yes, that is correct.
And no investigation was conducted by either you or anyone on the prosecution to see whether he actually received that notification, right?
No, I don't believe so, though it is common with the Ring security camera system to have these notifications in place.
But Ms. Cusack, it's still your belief that Mr. Brackman, while he was sitting at the table, still thought somebody was trying to break in, correct?
Yes, that is correct.
And isn't it fair to assume that as he received more notifications about the intruder moving from the front door to the back of the residence, right?
I believe these notifications would have alerted him that this intruder had intent to eventually enter into the residence.
Right. And Mr. Brackman knew this, correct?
Yes. And if he did have his notifications turned off.
Thank you, Ms. Cusack. You answered my question. And I'd like to clarify that Mr. Brackman did not call 911, did he?
I don't believe so, no.
And as the intruder moved around to the back and Mr. Brackman received those notifications, isn't it true that Mr. Brackman did not run out the front door to call the police?
No, I don't believe so, though. I mean, I believe it also could have happened in a short time when he...
I'm sorry, Ms. Cusack, I didn't ask why he didn't run out the front door. I asked if he ran out the front door. Yes or no?
Your Honor, I asked that Mr. Dudzik would stop cutting off my witness, please.
I'll overrule the objection for now.
Ms. Cusack, did Mr. Brackman run out the front door or not on March 6, 2020?
No, he did not.
Well, at this point, you believe that Mr. Brackman is in a frantic state, correct?
Yes, I believe so.
And you took images and were at the crime scene, correct?
Yes, I was.
And those images include an image of a knocked over plate, right?
Yes, that is correct.
Please turn your attention to Exhibit 9. Do you recognize this image?
Yes, I do.
And what is it?
This is a photo of the broken plate.
And is it a fair and accurate representation of that image?
Yes, it is.
Your Honor, I move to enter Exhibit 9.
Any objection?
No objections, Your Honor.
Exhibit 9 will be admitted.
Now, Ms. Cusack, you just stated that Mr. Brackman was in a frantic state, and it's fair to assume he was searching for a weapon, like you said on direct?
Yes, that's right.
And you also said that he was sitting at this counter?
Yes, but I believe he would have gotten up to be able to arm himself.
Right. And instead of arming himself with the scissors that are right next to where he was sitting, Ms. Cusack, he searched around his house for another weapon. Isn't that right?
Yes, that's right.
And so Mr. Brackman moved to the kitchen to get a knife instead, right?
Yes, that's right.
And at this point, you believe that the intruder is moving around from the front of the residence to the back, and now they've made their way to the glass door in the back, right?
Yes.
And it's your belief that the intruder never saw Mr. Brackman armed with a large knife inside a glass door, right?
Would you mind repeating that question, please?
Ms. Cusack, it's your opinion that the intruder never saw Mr. Brackman armed with a large knife inside the glass door. Yes or no?
I'm not entirely sure if the intruder was able to see that.
Now you believe that the intruder entered the residence as we saw in Exhibit 12.
Yes.
And as you stated, immediately inside the residence, there was some sort of scuffle, right?
Yes, that is correct.
And Your Honor, permission to screen share Exhibit 12.
Go ahead.
Now, Ms. Cusack, if we pause right here, there's no sort of scuffle just inside the door, is there?
Well, I would also like to add there is a bit of a glare that you can also see, that you're mainly seeing the back side of the house rather than the inside.
I'm sorry, Ms. Cusack, that wasn't my question. My question was, there's no indication of a struggle in this video, is there?
Well, I am seeing quite a glare, and also it happened towards the right of this back door, which is sort of outside of the camera lens.
Now, Ms. Cusack, you also reviewed scuff marks at the crime scene, right?
Yes, that is right.
Please turn your attention to Exhibit 18. And what are these?
These are the scuff marks I was able to review.
And is it a fair and accurate representation of those scuff marks?
Yes, it is.
Your Honor, I move to enter Exhibit 18.
Any objection?
No objections, Your Honor.
Exhibit 18 will be admitted.
Ms. Cusack, you also reviewed images of the victim, Mr. Brackman, at the crime scene, right?
Yes, I did.
And please turn your attention to Exhibit 1. Do you recognize this image?
Yes, I do.
Is it a fair and accurate representation of Mr. Brackman when he died?
Yes, it is.
Oh, I believe it's already been entered into evidence. I apologize. So looking at Exhibit 1, we can see that Mr. Brackman is not wearing shoes, correct?
Yes, that is correct.
Now, moving back to Exhibit 18, on direct examination, you said that these scuff marks indicate that more than one person created these marks. Isn't that right?
Yes, that is right.
But isn't it true that Mr. Brackman was not wearing shoes on the day of March 6th when he was killed?
Yes, that is true.
Now, moving on, you, the intruder, in your opinion, was able to gain control of the knife once in this scuffle, correct?
Yes, that is correct.
And that's when the intruder stabbed Mr. Brackman in the back, correct?
Yes.
And once that happened, in your opinion, the intruder fled the scene, correct?
Yes, that is correct.
And Mr. Brackman pulled the knife out of his own back, right?
Yes.
Now, you know this timeline of where Mr. Brackman was stabbed based on images, correct?
Yes, that is correct.
And these blood splatter images, to be exact, were actually lost, correct?
Yes, though I was able to review them prior to them being corrupted.
And Ms. Cusack, you inserted these images into your own spreadsheets, didn't you?
Yes, I did.
So isn't it true that you too lost these photos given they were inserted into your own spreadsheets?
Well, I was able to review them and place them into my spreadsheet.
Sorry, Ms. Cusack, my question was not whether you could review them. My question was whether you lost them. You lost them, didn't you?
They were lost after my review, yes.
I'm sorry. My question was not when they were lost. My question was if they were lost. You and Detective Markowitz both lost these photos. Isn't that correct?
Yes, unfortunately.
Now, moving on, Ms. Cusack, you, in your flowcharts that you mentioned on direct examination, you conducted some interviews, right?
Yes, that is correct.
And these interviews, and you heard Detective Markowitz on direct examination testify that she was not able to get an interview with Ms. Becker, the defendant, correct?
Yes, that is correct.
But in your flowcharts, you had an interview with Ms. Becker on June 5th, 2020, right?
I did, yes.
And you made a statement in this case, didn't you?
Yes, I did.
And in the statement, you swore to include everything you deemed relevant to the case, right?
Yes.
And before today, you were able to update that statement if any new relevant information was presented to you, correct?
Yes, that is correct.
Yet you didn't deem it relevant enough to include your interview with the defendant, Ms. Becker, in that statement, did you?
I did not add it in my statement.
Thank you, Your Honor. I have no further questions.
Any redirect examination?
No redirect, Your Honor.
All right. This witness may step down and the people may call their next witness.
Your Honor, the prosecution calls Alex Cifuentes to the stand.
All right. Go ahead whenever you're ready.
Before I proceed, I request a brief time check.
Yes, you have about 7 minutes, 23 seconds.
Thank you. Hello, Ms. Cifuentes.
Hello.
Would you please introduce yourself to the jury?
Good afternoon. My name is Alex Fuentes, and I'm a junior at Colorado High School. Most people call it CHS. And while attending CHS, I participated in the mock trial team.
Thank you. And would you further describe your experience while you participated in mock trial?
So I began mock trial freshman year when one of my best friends, Avery, convinced me to do it. I really liked it. I worked really hard and I really enjoyed participating in tournaments and practices.
And Ms. Cifuentes, would you elaborate more on your relationship with your mock trial teammates?
Yeah, so for starters, Avery Becker, for instance, had some trouble to take mock trial seriously and developed some issues within the team. Avery was just super bright, but didn't always prepare as much as the rest of us did for mock trial. Frequently came to practices late and even tournaments for that matter unprepared.
Thank you. Your Honor, I would now ask that Avery Becker turn her camera on for purposes of identification.
All right.
Ms. Cifuentes, do you see Avery Becker on screen today?
I do, yes.
And would you describe how Avery Becker appears in court today?
I believe she is wearing a black blazer and a white shirt.
Thank you. Your Honor, let the record reflect that Alex Cifuentes has identified Avery Becker as the defendant in court today. Your Honor, I no longer need Avery Becker's presence on screen. Thank you.
All right, the record will so reflect.
Now, Ms. Cifuentes, earlier you mentioned the issues that you experienced with Avery on mock trial. Would you describe more about these issues, please?
Yeah, so Avery had some troubles, especially with our coach, Coach Brackman. Coach Brackman was really frustrated with Avery's unfrequent preparation and frequently came to practices late. And I remember this one time, Avery came to practice late for the up team's time. So Coach Brackman kicked Avery off of A team, bumping them down to B team. And Avery then convinced Taylor Perkins, their other friend, to quit mock trial so Avery could rejoin A team. And our whole team was upset.
And was this the end of the dispute between Avery Becker and Mr. Brackman?
No, so after that, Avery won Best Attorney Award and Best Closing Argument at Regionals. And Coach Brackman came up to talk to Avery, and he basically said that what Avery did was not professional and not good lawyering. So Avery was extremely frustrated and vandalized his car after that.
And after the incident with Mr. Brackman's car, did you hear from Avery at all?
Yes, so shortly after that incident, Avery texted me.
And would you describe what Avery texted you?
Avery basically asked me to speak with Coach Brackman and asked me to convince him or convince her to let her back on the team. And so I said I would go up to Coach Brackman and see if Avery could get back on the team. But Coach Brackman wouldn't budge. So I texted Avery and told him that.
And what was Avery's response to hearing that he wouldn't be allowed back on the team?
Avery said that if Brackman thinks upset about what happened to his car, wait till he sees what I do to his house. I texted Avery back, extremely concerned, and asked her what she meant. And Avery said that she planned to go to Coach Brackman's house and trash it.
And after this text interaction with Avery, what happened?
Well, after that, I heard about the passing of our beloved coach.
And did the police contact you at all after Mr. Brackman's death?
Yes, so I believe the day after I get a call from the police detective asking to do a full interview. Now, I didn't want to rat Avery out. They were my best friend, but I could never lie about what happened, not something this serious. So I showed the detectives the screenshots of the text that Avery had sent me.
Now, Ms. Fuentes, what happened after your interview with the police detective?
I believe an investigator came to my house and tried to interview me. Now, I didn't really trust this investigator. I have been a part of mock trials, so I knew that they were just trying to get things to frame me in court, so I refused an interview. Even still, she asked me a few questions, and I basically learned I was accusing of faking these texts with Avery. I mean, seriously, why would I create a fake text exchange? Like I said, Avery was one of my best friends. I really cared about her.
And was there anything else that happened after your interaction with the private investigator?
So after that, I found out that Avery was accusing me of stealing their phone and giving it to some rando Blair Rollins. I mean, I went to the same school as Rollins, but so did Avery Becker, Taylor Perkins, and every other student on the CHS mock trial team. I didn't really have a meaningful relationship with Rollins. I mean, I said hi to them in the hallway, but I certainly did not steal Avery's phone and give it to him.
Honestly, Ms. Fuentes, it sounds like you and Avery weren't getting along by the time Coach Brackman died.
So that's so not true. I know there's a rumor that Avery and I were rivals. It's totally false. Avery and I were teammates. We were best friends. She introduced me to the thing I love most, and we pushed each other to be better. I saw the potential in Avery, and I knew how good she could be. So this rumor is totally false. We were teammates. I specifically remember that Avery even thanked me for asking Brackman to let her back on the team. She said that I should win the Best Attorney Award that year. So whatever people say, Avery and I were friends.
Thank you, Ms. Fuentes. I have no further questions, Your Honor.
All right, any cross-examination?
Yes, Your Honor. Good afternoon, Ms. Fuentes.
Good afternoon.
You stated on your direct that you were best friends with Miss Becker,
Yes.
but you never hung out with her outside of mock trial, did you?
No, I was really busy with mock trial. I mean, it's my passion, so I never really hung out with her besides the Fry Shack.
In fact, you were jealous of her.
I just saw the potential in Avery, and yes, I believe she was better at me than mock trial, but in some skills.
You were excited for the larger roles you would receive when Miss Becker was no longer on the team.
I wouldn't say, I don't know, like, I'm sorry, could you repeat that question? I couldn't really hear you.
Yes. You were excited for the larger roles you would receive when Miss Becker was no longer on the team, weren't you?
I mean, in mock trial, there aren't really larger roles. So sure, I would be excited. I think the team would have been better off without Avery just because of her frequent late to practice, and she was just never prepared.
In fact, you were the one who would benefit the most with her off the team, weren't you?
I mean, I would say so.
Now let's move on to texts you say Miss Becker sent you. Permission to show Exhibit 14 on the screen. Now, Mr. Fuentes, nowhere on this screenshot are there any phone numbers indicating Miss Becker. Sorry, let me phrase. Nowhere in the screenshot is there a phone number.
No, not on this current screenshot, no.
And there are also no date or timestamps indicating when the texts were sent or received.
No.
Permission to stop viewing Exhibit 14. Okay. You took
Your Honor. Pursuant to the stipulated facts of this case, the chain of custody of the evidence is not to be questioned, as the opposing counsel has just done.
I'm sorry, so which question were you objecting to?
Her line of questioning, which regarded the credibility of where the text came from.
Do you have a response?
Yes, Your Honor. I was simply asking what has already been admitted as Exhibit 14, not about the authenticity, but purely if Avery Becker did send these texts. And there are no date or timestamps indicating when that would be. I was simply asking Ms. Fuentes' perception of that.
Right. I'm going to overrule the objection. I don't find that line of questioning went to chain of custody as it's that phrase is intended within the stipulations. So you may proceed.
Ms. Fuentes, you didn't take the text that Ms. Becker seriously, did you?
I mean, I was concerned.
You were concerned, but you didn't call the police about this threat.
No, I did not call the police.
You also didn't tell your coach it was possible his house would be broken into, did you?
No, I don't say that in my witness statement.
Now let's move on to your interview with Detective Markowitz. You say you completely forgot to bring your phone to the interview, didn't you?
Yes, so my phone was really old, so of course I left it on the charger because I made sure I wanted to use my phone.
So Detective Markowitz never looked at your phone, did she?
No, she said she was fine with the screenshots that I sent her.
She only looked at screenshots you took and you sent to her, didn't she?
Yes.
But that's okay because you didn't want the police to examine your phone, did you?
I would have been fine with the police examining my phone. I put it on the charger so I could take my phone to the interview.
But you forgot this phone and didn't bring it.
Yes, it was such an accident. I totally spaced.
You have a new phone now.
I do, yes.
You've gotten rid of the old phone with the text messages on it, haven't you?
Yes, I got a new phone this summer because that old phone just did not hold a battery.
So as of right now, you have no idea where your phone is.
I mean, you'll have to ask the guy at AT&T. I could not tell you where it is.
You were asked some questions by Professor Blake Van Owen, weren't you?
Yes, I was asked just a few questions.
But you didn't respond to any of these, did you?
No, I didn't necessarily trust this private investigator.
So it doesn't really sound like you were best friends with Avery Becker, does it?
I mean, the way that I handled this really serious allegation wasn't a reflection of our friendship, I would say.
Now let's move on to another. Oh, sorry. Let's move on to another student at Colorado High School. You know a person named Blair Rollins, don't you?
I do, yes.
You went to Colorado High School together.
I did.
You are aware that Coach Brackman represented a student's father at Colorado High School.
Yes, I'm aware of that.
Now let's move on to March 5th at the Fry Shack. You saw Miss Becker there, didn't you?
Yes, I did.
She was very nice to you.
Yes, she let me play a game on her phone.
You two talked about how she should move forward from the team, didn't you?
Yes.
She thanked you for this advice.
Yes.
So as of March 5th, there weren't any angry or bitter feelings that Miss Becker had over mock trial, were there?
No, like I said, we were really good friends.
You played a new game on Miss Becker's phone right before it went missing, didn't you?
I did, yes.
But you had your own phone at the Fry Shack, didn't you?
I don't say that in my witness statement. Would you like me to respond?
No, that's all right. You had possession of Miss Becker's phone right before it went missing, didn't you?
I think the day before it went missing, or I don't really know about the missing phone, but I had possession of her phone at the Fry Shack.
No further questions.
All right, any redirect examination?
Yes, Your Honor, a brief redirect.
Go ahead.
Ms. Fuentes, when you were using Miss Becker's phone at the Fry Shack, you were simply playing a game. Would you say?
Yes. Yes, I was. She just went to the bathroom and I was just playing a game because she has a higher level on this one game. So.
And you didn't take it to your house at all?
No.
So you weren't in possession after you played the game, correct?
No.
Thank you. I have no further questions, Your Honor.
Thank you. This witness may step down. Are there any other witnesses for the prosecution?
Your Honor, the prosecution rests.
All right. Any witnesses for the defense?
Yes, Your Honor. The defense calls Avery Becker.
All right. Go ahead whenever you're ready.
Good afternoon, Ms. Becker. Please state your name and spell your last name for the record.
My name is Avery Becker, Becker.
Why are you here?
I'm here because the prosecution is trying to convince you that I killed my own mock trial coach, and I can't believe this is happening to me. I mean, I can't believe Coach Brackman's dead.
Now, there's been a lot of testimony today about your relationship with Mr. Brackman. Can you explain how that relationship actually was?
Coach and I definitely had a rocky relationship. We didn't always get along 100% of the time. We disagreed on a few things, but in the end, we really needed each other to succeed in mock trial and to get our team to the top.
What roles did Mr. Brackman give you?
Last year, our case was pretty simple. It was about these two old people who were arguing over their mother's will and who got the money. I was the one who got to cross the doctor, and I directed the mother's nurse.
Were these good roles?
Yes, I would say so.
Was there respect within your relationship with him?
Yes, of course. I mean, he gave me pretty good roles, and in return, I did pretty well for our team.
Now, let's talk about the regional tournament of last year. What happened before this tournament?
Coach and I got in a little disagreement, mainly about my work ethic. Coach didn't think I was working hard enough, but mock trial came so easy to me, and so it just didn't take a lot of time.
What happened after this?
Coach was antagonizing me, and he demoted me to the B team, which I couldn't believe. I mean, I had to cross the dog walker.
And what happened after this?
My best friend, Taylor Perkins, she didn't really like mock trial that much, and so she stepped down, and I was able to get back on the A team.
How did you do at regionals?
We did awesome. We won, so that was really, really exciting.
How did you do?
I got the best attorney award and the best closing award. I was really proud of myself.
And after all of this, how was your relationship with Mr. Brackman?
Oh, it got worse. Coach was so salty that I had won personally any awards at all. And he told me that in front of the whole team that I didn't deserve those awards, and I only got them because I looked good.
And what happened after this?
I was so humiliated. I mean, that was so embarrassing, and I was really disappointed. I thought that my coach was going to get behind me, and I was about to write on the whiteboard about all the good things we had done, and I walked out, and I was so upset and embarrassed at what he said, and I did something really stupid. I wrote on his Porsche, and I never should have done that, and I really am sorry.
What marker did you use?
I really, really thought it was a dry erase marker. I was about to write on the whiteboard, and I thought that once I had written on the car, it would just come off just like you would just erase like on a dry erase board. I didn't mean to really permanently damage his car.
What happened after that?
Coach came and he saw the car, and he was livid. He yelled at me and told me that I was off the team for good.
Did you apologize to him?
Yes, I tried to apologize so many times. I tried to go in person and apologize, but he wouldn't see me. And I texted him and I tried to apologize that way, but he never responded. And now I'll never be able to apologize to him because he's dead.
How do you feel about this situation now?
Looking back on it, I never should have written on that car. I feel awful for what I had done, and I'm so ashamed of my actions.
Now let's talk about March 5th. What did you do that day?
Oh, Taylor and I went to the mall and the Fry Shack to hang out.
What happened at the Fry Shack?
We saw a bunch of my mock trial teammates there, including Alex Cifuentes.
Who is Alex Cifuentes?
Alex. She was a kid on my mock trial team, and she just testified that we're friends, but honestly, I was shocked because we're not friends at all.
And how was your relationship?
I mean, we really didn't know each other entirely well. We only saw each other really at mock trial, and I didn't really want to hang out with her. We weren't friends, let's put it that way.
And did you hear her talk about alleged text messages you sent her?
Yeah, that's crazy because I had no reason to text Alex. I mean, we're not friends, and I never would text her for any reason.
So are those your messages in Exhibit 14?
Absolutely not. I don't know where those came from. I've never seen those before in my life. She must have made them up or something. They must have come from somewhere else, but I know they didn't come from me.
Did you have your phone with you the whole time on March 5th?
No, I didn't. For some reason, Alex wanted to play games on my phone, so I gave her my phone.
Did you have your phone when you left the fry shack?
Honestly, I can't remember really, but I do remember the last place I had it was when I gave it to Alex at the fry shack so she could play games on my phone.
When did you realize you had lost your phone?
The next morning, I woke up and I couldn't find it.
What did you do after that?
Taylor and I skipped school to go find it. I mean, phones are pretty expensive after all, so I mean, I didn't want to lose it, so we went and basically retraced our steps. We went to the fry shack and we went to the mall.
Did you try to call your phone?
I did multiple times. Taylor and I both tried calling and texting it, but nobody would answer and it just went straight to voicemail.
Did you ever find your phone? I'm sorry, did you ever find your phone?
No.
Now, who is Blair Rollins?
Blair is a kid at my old high school. He was my classmate.
And how do you know him?
I mean, he was my classmate. He went to CHS, and I've heard a lot of things about Blair, and I know a few things about him.
And what rumors did you hear about Blair?
I mean, everybody at CHS and within the community too knew that Blair absolutely hated Coach Brackman.
Objection, speculation. Ms. Becker cannot testify to what everyone in the community knew.
Response?
Your Honor, the foundation has been laid that Ms. Becker went to CHS, knew the community, had been there for 4 years, and according to Rule 701A, she can testify rationally based on her own opinion, and this is rationally based on her experiences, and she would be able to testify about rumors that were going on at the school and in the community.
In response?
The foundation has been laid that she can make an opinion about what her community thinks, but to say that everyone in the community thought something of Blair Rollins is stretching the truth and speculation.
All right, I'm going to sustain the objection.
Now, Ms. Becker, what did you hear as the rumor, and what did you believe, not what the community believed?
I believe that I had heard from many different people that Blair hated Coach Brackman because Coach Brackman was the defense attorney that lost Blair's father's case, and Blair's father got sent to jail.
Are you and Mr. Rollins approximately the same size and build?
Yeah, I would say so.
And based on your personal observations, do you believe that Mr. Rollins and Alex Fuentes are friends?
Definitely, 100%.
Now, I'm sorry to ask you this, Ms. Becker, but were you at Mr. Brackman's house on March 6th?
No, absolutely not. I don't want to know where he lives, and the only place I ever saw him was at mock trial practice.
Did you see Exhibit 12?
I did.
Is that you?
No. Oh my gosh, no. I was never at Coach Brackman's house. I don't know where he lives, and I would never go there.
Did you kill Mr. Brackman?
Absolutely not. After what I did to the Porsche, I'm so ashamed of what I had done, and I never would have hurt Brackman in any other way.
No further questions, Your Honor.
All right, any cross-examination?
Yes, Your Honor.
Go ahead.
Good afternoon, Ms. Becker. I'd like to start with your relationship with Mackenzie Brackman when you were on the mock trial team. You and him never quite got along, did you?
We didn't always see eye to eye on certain things, but we needed each other.
It was your impression that he thought you were lazy, stuck up, and disruptive, correct?
Not stuck up, but definitely he has called me lazy before, mainly because he couldn't understand how easy mock trial was for me, and I really didn't need to take a lot of time on it.
He often criticized your work ethic.
He did. He had called me lazy.
And even though you had won a big award at regionals, you thought he was angry at you the next practice because he believed your lack of work ethic would hurt the team at state, correct?
He was really upset that I had won an award, and he told me in front of the whole mock trial team that the only reason I had won was because of my looks.
So you got angry at him and wrote worst attorney award on his car and what you now say you thought was a dry erase marker?
I never should have done that. I was so humiliated and upset, and I never should have written on his Porsche. I tried so many times to apologize to him for what I had done, but he wouldn't listen to me.
So you vandalized his property.
I didn't mean to permanently do anything to his car. I really thought it was a dry erase marker and that it would just come right off, just like when you wipe a whiteboard down.
But you did vandalize his property, correct?
Yes, and I didn't know it was a permanent marker.
And once he saw what you had done to his car, he kicked you off the team, correct?
Yes, he was furious.
And you were upset?
I couldn't believe that was how my mock trial career ended. I had been on the team for 4 years.
You were angry?
I was upset because of all the events that had happened, and later I became really ashamed of what I had done. I never should have written on his Porsche like that, and I never would do anything else to Coach Brackman. I really did try to apologize to him many times.
You were willing to get him back if it was the last thing you did?
I think you're taking that completely out of context. I was simply just venting to my mother. I was so upset and I was crying and I just couldn't, I was just saying whatever came out of my mouth, but I didn't mean any of that. I never would hurt Coach Brackman like that. If you're implying that I murdered him, I didn't do that at all.
However, you felt at the time that you would get him back if it was the last thing you did.
In the moment, I suppose, but I really didn't mean to carry any of that out. I was just simply venting to my mom.
Now, apologies. You say that you were willing to get him back if it was the last thing you did because you cared a lot about mock trial, correct?
I didn't put a lot of work into it. And sure, it was an extracurricular. Sure, maybe I did pretty well, but I didn't love it enough to do like anything, huge. I wouldn't risk my life for just something that I did on the side.
Now, you say that you would never trash Mackenzie Brackman's house, correct?
No.
But you had already vandalized something of his, hadn't you?
Objection. Improper character evidence.
Response, Your Honor.
Yes.
Pursuant to Rule 404B2, this is admissible because it speaks to the defendant's potential motive as well as identity.
Response?
Your Honor, in accordance with Rule 403, this trait of vandalizing the car is going to show that Ms. Becker again would vandalize his house and therefore is improper character evidence. I'm sorry, Rule 404.
Response, Your Honor.
Well, question, isn't the evidence of the damage to the car already before the jury at this point?
Yes, Your Honor, but he's going further to say that since she vandalized his car, she would again do this through this line of, or through this actual question.
Response, Your Honor.
Sure.
Opposing counsel does not know my line of questioning, and furthermore, vandalizing a car is not a character trait, it is just a past action.
What was the question that you had asked?
The question I asked was that you had already vandalized something of his, hadn't you?
All right. I understand the objection. I'm going to overrule it at this time.
Ms. Becker, you had already vandalized something of his, hadn't you?
I did, and I never intended to do anything else to Coach Brackman. I'm so ashamed of what I had done to his car. I never should have done that. I never should have stooped to his level when he got angry at me, and I really am sorry for what I had done.
Thank you. And Ms. Becker, that was the first time when you vandalized his car, that was after he insulted you, correct?
Well, he had embarrassed me, and I was upset about that, yes.
And this was more drastic. Not just insulted, this time he kicked you off the team. Your mock trial career was over, wasn't it?
Compound question.
Your Honor, I've only asked one question.
Overruled.
I'm sorry, can you repeat the question, please?
Yeah. Ms. Becker, this time it was more drastic, wasn't it? Your mock trial career was over.
I mean, it was definitely something that it was a hard pill to swallow. I mean, I had been kicked off. I couldn't believe it, but I mean, I was really sorry for what I had done, and my actions were just not acceptable.
Finally, I'd like to talk about the location of your cell phone. You claim that you lost your phone the day before the murder at the fry shack, correct?
Yes, the last time I remember seeing my phone was when I gave it to Alex Fuentes so she could play games on my phone. For some reason, she wanted to play games on my phone, so I just gave it to her.
In fact, you claim that your phone was likely dead or stolen, correct?
Yeah, I mean, Taylor and I went all around. We were with each other the whole day on March 6th, and we were trying to find it. So we were calling it, we were texting it, but to no avail. I mean, we really couldn't find it anywhere.
As you said, you and Taylor Perkins tried calling your phone, correct?
Yes.
Now, according to Detective Markowitz's previous expert testimony, your phone communicated with 3 cell towers near your house and Mackenzie Brackman's house right before the time of the murder. You claim your phone had been, you claim you had lost your phone, correct?
Objection, Your Honor, compound question.
Your Honor.
Overruled.
You claim, however, I can re-ask the question. You claim that you had lost your phone, correct?
I did lose my phone. It's gone. Taylor and I never found it.
So around 24 hours had passed since you lost the phone and you and Taylor went to look for it.
Well, I mean, yeah, I mean, I lost it at the fry shack the day before, and I couldn't find it after that.
So you believe that your phone, which had been lost or stolen for an entire day, happened to be moving around in between your house and Mr. Brackman's house right before the time of the murder without it being in your possession?
I mean, I don't know where my phone went that day. I couldn't find it. I didn't know where it was. So I have no knowledge of where my phone was or where it was going. I didn't have my phone.
You heard Detective Markowitz's testimony, correct?
I did.
Thank you, Your Honor. I have no further questions.
Any redirect?
No, Your Honor.
All right. This witness may step down. Does the defense have any further witnesses?
Yes, Your Honor. The defense calls Taylor Perkins.
All right. You may proceed when you're ready.
Good afternoon, Ms. Perkins. Please state your name and spell your last name for the record.
Taylor Perkins, Perkins.
Ms. Perkins, do you know the defendant, Avery Becker?
Yes, I do. We were friends all throughout high school. We went to CHS together.
While you were at CHS, what sort of activities did you do there?
I was on the mock trial team with Avery.
And how long were you on the mock trial team for?
I was on the team for 4 years until I stepped down right before regionals in my senior year.
Why did you decide to join mock trial?
I mostly just wanted to hang out with Avery, plus it was something fun to do after school. I'm not really passionate about being a lawyer or anything.
Ms. Perkins, you just testified that you were on the mock trial team for nearly 4 years with Ms. Becker. I want to ask you some questions concerning Ms. Becker and Coach Brackman's relationship on the team. What was their relationship like in mock trial, from what you observed?
Your Honor. Objection, Your Honor. This question calls for speculation. This witness is neither Avery Becker nor Mr. Brackman and can't testify to their relationship.
Response.
Yes, Your Honor. Under Rule 701, Ms. Perkins is allowed to opinion testimony about her rationally based perception in this case. She's simply describing what she observed over near 4 years on the team with Ms. Becker and Coach Brackman. It is based on her rationally based perception.
Right. Court does find that the witness can base an opinion on her rational perceptions, so we'll overrule the objection.
From your observations, what was the relationship like on mock trial?
I guess you could say Coach and Avery always had sort of a little feud going on. Coach Brackman was always giving Avery a hard time about something. Avery was genuinely a really good lawyer, but she could just be a little unprepared sometimes. That totally drove Coach insane.
Were there any specific incidents you recall of them having an issue?
Yes, there was this one time Coach demoted Avery down to the B team for basically no reason.
What happened next?
Well, after Avery was demoted, I decided to step down. I wanted to support her. It wasn't really a hard decision for me to make.
Did Miss Becker ever get back onto the A team?
Yes, she did. Once I stepped down, she was reinstated.
What happened after that?
Well, they all went to regionals and Avery won a bunch of awards. She's really amazing.
Let's now talk about March 5th at the Fry Shack. Where were you that day?
I was with Avery.
What did you and Miss Becker do this day?
Avery had come over to my house. We just sort of hung out there for a while, and then we went to the Fry Shack to grab a bite to eat.
Who was at the Fry Shack that day?
Well, while we were eating, the entire mock trial team showed up. I should have known they'd go there after practice.
Do you recall Miss Becker having her phone at the Fry Shack that day?
Yes, I remember it being on the table where we were eating, but that's the last time I saw it.
What happened next?
Avery got up and went to the bathroom. That's when she left her phone on the table, I think.
Who was at that table?
Alex Cifuentes was there. He had come over to talk to us.
And what happened next?
Avery came back from the bathroom and we just went to the mall.
Do you remember seeing Miss Becker on her phone at the mall at all?
No, the last time I remember seeing it was definitely on the table at the Fry Shack.
Now, Miss Perkins, you just testified that you saw Alex Cifuentes at the Fry Shack. How do you know Alex Cifuentes?
She was on the mock trial team with us.
From what you observed, were Alex Cifuentes and Avery Becker friends?
I mean, not really. I guess you could say they were polite on the surface to each other, but deep down, not so much. It always seemed to me like Alex was jealous of the roles that Avery got on the team.
Objection, Your Honor. Speculation. This witness is testifying to the thoughts of Alex Cifuentes rather than what she observed, and therefore it is speculatory.
In response?
Yes. Again, this is under Rule 701. Opinion testimony is permissible if it is based on the witness's rationally based perception. I'm simply asking Avery Becker's best friend what she observed an encounter between two people, Alex Cifuentes and Miss Becker, and what she viewed as their relationship like.
I think this is a little bit different. I think this isn't asking the witness to describe a relationship as she observed it. It's what the witness just testified to was the person's feelings. So I am going to sustain that objection.
I move on, Your Honor.
Your Honor, I ask that the testimony be stricken from the record.
It will be.
Do you know of a person named Blair Rollins?
Yes, I do. He went to CHS.
How well did you know Blair Rollins?
Not very well, but rumors go around.
What were these rumors at Colorado High School?
Well, I guess you could say Blair sort of had the reputation for being the kind of guy that could totally kill someone and not even think twice about it.
And from what you observed, were Blair Rollins and Alex Cifuentes friends?
Yeah, they hung out a little bit.
Now let's move on to March 6th, 2020. Where were you that day?
I was with Avery the entire day. We were searching for Avery's phone.
How did you realize that the phone was missing?
Well, Avery and I sort of have this routine where she'll pick me up from school sometimes, especially when we have a free period. That morning I had texted her to see if she was coming to my house, but she never responded. She did end up coming, but once I got in the car, that's when we realized that her phone was missing.
Why did you decide to skip school that day?
Well, I wanted to help Avery look for her phone. I mean, it's a pretty expensive thing to own.
Please tell the jury of all the places you went to that day to search for Miss Becker's phone.
We went to the Fry Shack, the mall. We retraced our steps, basically.
Did you ever end up finding Miss Becker's phone?
No, we could never find it. It's still missing.
And what sort of efforts did you do other than searching for it to find the phone?
Well, I called and texted Avery's phone several times to see if we could hear it ringing, but we never did end up finding it.
Did you go anywhere near Coach Brackman's house that day?
No, absolutely not. We were looking for Avery's phone the whole day.
Do you even know where Coach Brackman lives?
I mean, no. I think it would be kind of creepy if I did.
No further questions.
All right. Cross-examination.
Yes, Your Honor. Good afternoon, Ms. Perkins.
Good afternoon.
You went to Colorado High School.
Yes, I did.
And at Colorado High School, you participated in the mock trial program.
I was on the team with Avery.
And your coach was Mackenzie Brackman,
Yes, he was my coach all 4 years.
but you and Mr. Becker didn't always agree with Mr. Brackman.
I mean, I guess I thought he was a mediocre coach. He made some bad decisions for the team.
And you also say that you thought he was a mediocre lawyer as well.
Yeah, that's true. Avery was kind of better than him, actually.
And as you've testified today, you say that Miss Becker and Mr. Brackman's interactions were sort of like a little feud.
Yeah, they had a few arguments. It annoyed Avery a little bit, but not enough to murder him.
You state that Miss Becker drove Mr. Brackman crazy.
Yeah, she kind of did sometimes. He was always pretty upset about her preparedness.
But you never really got involved in their arguments, correct?
No, I guess I thought it was kind of funny. I didn't really deem it necessary, to be honest.
However, you do state that Miss Becker could be rash.
She could be rash, but she wasn't irrational enough to commit murder.
And
improper character evidence, move to strike.
Your response?
Your Honor, my Miss Perkins has already testified about this in her witness statement, and I am simply using this to show what have been intent and past actions of the defendant.
Response, Your Honor.
Sure.
The prosecution is trying to prove that because at a time Ms. Perkins viewed Ms. Becker as rash, she would go as far enough to kill her coach, and that is improper character evidence under Rule 404.
I'm gonna overrule the objection. You can certainly raise whatever issues you have with how the jury ought to take that evidence in closing argument.
And you also state that Miss Becker had an inflated ego, correct?
Yeah, I guess Avery could be like that sometimes.
And after one argument with Miss Becker, you say that Mr. Brackman got particularly heated.
Yes, when he demoted her down to the B team.
And then you stepped down from A team, correct?
I did.
So that your good friend, Miss Becker, could be back on the A team, correct?
Well, I didn't know if she would be reinstated or not, but once I stepped down, she did get back on the A team, yes.
But Miss Perkins, the intention of you stepping down from the A team was so that Miss Becker could be reinstated to the A team, correct?
I didn't really care that much about mock trial. It meant a lot to Avery. So yeah, I would say that's correct.
All right, I'd like to move on and discuss the night on which Miss Becker vandalized Mr. Brackman's car. Now, one night, Miss Becker and Mr. Brackman got into yet another argument, correct?
That is what I heard, yes.
And after this argument, Miss Becker vandalized Mr. Brackman's car, correct?
Avery had told me that, yes, but I wasn't present that day.
Move to strike, objection, improper character evidence.
Your response?
I would ask that counsel clarify her objection as to what she's objecting to more specifically.
I'm objecting to the vandalism, that they're trying to prove that because Miss Becker vandalized Coach Brackman's car this day, that she would go as to vandalize Coach Brackman's house, which resulted in murder, which is just not the case and would follow in that character trait.
Any response?
Your Honor, this evidence has already been admitted to the jury, and this is not being used to show the character of Miss Becker. Rather, it is being used in a line of questioning that will go to her intent.
The court will overrule the objection.
In your witness statement, Ms. Perkins, you say that Miss Becker did this to let off some steam, correct?
Yeah, I mean, it was just like one of those pranks she played on him sometimes. I don't think she would be malicious in any way. It was an accident.
And again, in your witness statement, more specifically, you say that Miss Becker did this to freak Coach Brackman out, correct?
Yes, I did say that.
And then, after Miss Becker vandalized Mr. Brackman's car, Miss Becker was kicked off the mock trial team once again, correct?
As a result of the incident, yes. But she was never kicked off previously, only demoted.
Thank you. I'd like to move on and now discuss the night you and Miss Becker went to the Fry Shack. Now, on this night, you say that you swung by her house, correct?
She swung by my house, yes.
Sorry, I misspoke, yes. And at your house, Miss Becker and you played games on your phones.
Yeah, we did. We sort of just hung out for a while and then we went to the Fry Shack.
And at the Fry Shack, Miss Becker got upset, correct?
She was a little bit upset, mainly about what had occurred prior to that day, her being kicked off. Plus, I think Alex was making her upset as well.
Mm-hmm. And she left her phone on the table when she stormed off to the bathroom, correct?
Yeah, I guess she was a little bit frazzled.
And this was really weird because, as you describe, Miss Becker's phone was like her third kidney, correct?
She was attached to it, yes.
As if it were her third kidney, correct?
Yes.
Thank you. While Miss Becker was in the bathroom, you spoke with Alex Cifuentes.
Yeah, Alex was at the table. He was being really annoying.
And you expressed your urge to punch Alex in the face at the time, correct?
I guess it was more of a figure of speech. I only meant that she was being super annoying. She's always been a kiss up to Brackman, and I think she was making Avery upset.
And that would warrant punching her in the face, as you wrote in your witness statement, correct?
I don't think I would have actually punched her. It was a figure of speech.
But you do express the urge to punch her in the face, correct?
Yeah, for sure.
Sorry, what was the objection?
Irrelevance.
Response?
I'm sorry, Your Honor. I'll move on. My line of questioning with that is done.
Can I have that stricken from the record, please?
That objection will be sustained.
Now, when you and Miss Becker left the Fry Shack, you weren't sure Miss Becker brought her phone with her, correct?
The last time I saw it was on the table at the Fry Shack. I'm not sure where she actually lost it, but I know that is the last time I saw the phone.
Thank you. I'd now like to discuss with you the events that followed Mr. Brackman's death. Now, Ms. Perkins, you say in your witness statement that when you heard Mr. Brackman had been killed, you and Avery talked about it.
Yeah, we did have a conversation about it. It was pretty shocking.
And after Miss Becker's lawyers called you, you talked to Avery again.
Yeah, they had called me about possibly being a witness. Honestly, I was really astounded. I had a conversation about it with Avery after.
So it's true that you spoke with Avery at least twice about Mr. Brackman's murder before you spoke with the police, correct?
I mean, she's my best friend. It was the hottest gossip. It was really shocking. We knew him for almost 4 years. I was just shocked. So we did talk about it, yeah.
You talked about it before speaking with the police?
Yes, we had a conversation about it.
And during one of these conversations, Miss Becker told you that Blair Rowlands might be involved in the case, correct?
She was the one who brought it up, but after she did, it just made so much sense. Alice could have taken Avery's phone at the Fry Shack and given it to Blair.
However, it wasn't a lawyer who told you that Blair Rowlands was involved, correct?
No, it was Avery who brought it up, but it made a lot of sense to me.
And again, it wasn't an investigator who told you that Blair Rowlands was involved.
No.
And finally, it wasn't a police officer either who told you that Blair Rowlands was involved.
No, it was Avery who told me that he definitely could be involved, and I do believe he is.
And finally, in your witness statement, you suggest that Alex Cifuentes gave Blair Rowlands Miss Becker's phone.
Yes, I think that Alex did do that. He also made up some weird text messages. It made no sense to me. Alex and Avery weren't friends. I don't know why she would have texted him.
However, you didn't witness any of this happen, correct?
Witness what exactly?
You didn't witness Alex Cifuentes give Blair Rowlands his phone, nor did you witness Alex Cifuentes fake text messages from Avery, correct?
No, but that is what I believe happened.
Nor did you witness Miss Cifuentes or Mr. Rowlands with Miss Becker's phone, correct?
I did, no.
So your theory that Alex Cifuentes stole Miss Becker's phone and gave it to Blair Rowlands is uncorroborated, correct?
Well, Alex was at the table with us at the Fry Shack, so I do believe that is what happened.
However, you have no concrete evidence that any of this happened, correct?
No, but Avery and my stories line up. It makes a lot more sense that Blair would have been guilty.
Thank you, Your Honor. I have no further questions.
Any redirect examination?
No, Your Honor.
All right, this witness may step down. Does the defense have any other witnesses to call?
Yes, Your Honor. The defense calls Professor Blake Van Owen.
All right. And go ahead when you're ready.
Professor, please state your name and spell your last name for the record.
Professor Blake Van Owen, Vanowen.
Professor, were you asked by the defense to give some expert opinion in today's case?
Yes, I was.
Did you reach any opinions?
I did.
Before we discuss them, I'd first like to talk about your background. Did you go to college?
Yes, I did. I went to CU Boulder, School of Buffs, and I also received my master's in criminal justice from Ashford University.
Professor, do you have any specific experience in police work?
Yes, I do. I was a part of the Aurora Police Department for about 9 months. And then now I am a professor at CU Denver, where I teach a class on police procedures as well as social justice.
Other than teaching a class, do you have specific experience with crime scene investigation?
Yes, other than acting as a professor, I am also a private investigator, obviously, as I am here today. And in my time working as a private investigator, I've had to learn and use many different skills in the field of investigation.
Have you ever testified as an expert like you're doing today?
Yes, I have. I've been a consultant for about 100 different cases, and I've testified as an expert a little over 25 different times.
And what kinds of things have you testified about?
I've testified during court in regards to police practices, their techniques. I've also testified in crime scene reconstruction, as well as cell tower analysis.
How do the areas, Professor, that you've testified in the past relate to the case that we're talking about today?
Now, all of these areas are highly relevant for today's case. I think a good way to think of it is it's as if you're asking a candy maker to testify about candy canes, candy corn, and jelly beans. He knows all of those different subjects. As an investigator, all of these subjects are highly pertinent for my expertise, and I know all of these to a fair extent.
Your Honor, at this time, I offer to tender Professor Blake Van Owen as an expert in the areas of police practices and investigation, including crime scene reconstruction, and cell tower analysis.
Any objection?
Your Honor, the prosecution requests a brief voir dire.
All right, go ahead.
Mr. Van Owen, do you have any medical training?
Medical training? No, I don't believe so.
Do you have any medical education?
No, not medical.
Sorry. Do you have any medical certification?
No, not in the field of medicine, in the field of investigation.
Do you have any expertise in the field of medicine?
No.
Nor have you previously testified specifically about medicine?
No.
Your Honor, I do not object to Mr. Dudzik's tenderings for Mr. Van Owen, but I would like to note that because Mr. Van Owen lacks training, education, knowledge, experience, and skill in regards to the field of medicine, pursuant to Rule 702, I ask that his testimony be limited to that of his tendering only, and that any and all medical opinions be excluded from his testimony.
Your Honor, if I may.
Yes, but first remind me what your tender was.
Your Honor, the tendering was police practices and investigation, including crime scene reconstruction and cell tower analysis. And then may be heard?
Yes.
Your Honor, pursuant to the Colorado mock trials competition rules, voir dire is reserved for the objection to a witness being tendered as an expert. I don't believe opposing counsel just objected to Professor Blake Van Owen being tendered as an expert witness, and I believe that testimony should have been reserved for cross-examination.
I hear what you're saying. However, I think that we're just trying to make sure that all parties are clear as to the scope of the witness's expertise. I anticipate, based on this exchange, that there may be some testimony that may be elicited or may not, that is in sort of a gray area as to whether it's expert or lay, or whether it's medical or non-medical. So the court's going to reserve ruling as to anything like that until unless that becomes an issue. As of now, since there's no objection to the tender as proposed by the defense, the court will so tender the expert.
Now, Professor, you said you reached some expert opinion in today's case. What were they?
I have three. The first one being that we can't place Miss Avery Becker at the scene of the crime on March 6th. Second, we have no knowledge as to what really happened inside of the home of Mackenzie Brackman. And finally, the police investigation was sloppy and poorly conducted.
Now, I'd like to first talk about your first opinion about Miss Becker's phone and her location on March 6, 2020. What led you to your conclusion?
To start, this was utilizing my experience in the field of cell tower analysis and recovery. I'd like to start by noting the prosecution wasn't able to show in any manner that Miss Becker had her phone on March 6th. Obviously, this is pertinent to the case because if Miss Becker had her phone, they claim it would place her at the scene of the crime. Now, I'd like to talk about that assumption that if she did have her phone, she would be at the scene of the crime.
Now, why don't you believe even if she did have her, if she didn't have her phone, it doesn't put her phone at the scene of the crime?
Now, Detective Markowitz painted this nice picture of how cell towers work, claiming that they can place people in specific locations. This is far from the truth. Now, what the cell tower tells us is that a person's cell phone is within a 37.7 square mile radius of a 120-degree arc. Area, not radius, my apologies. Now, this would simply tell us her general vicinity. It would be the equivalent of me saying that I was in Denver, and you would pinpoint me somehow at Coors Field. There's no logical coherence between these two claims.
Now, what does this tell you about Ms. Becker's phone's location on March 6, 2020?
The only thing we know about Ms. Becker's phone is that it was in the general area of Mr. Brackman's home. However, we can't place her phone at the scene of the crime on the day of March 6th.
And what does this tell you about Ms. Becker's location on March 6, 2020?
Ultimately, nothing. We have no idea where Ms. Becker was on the day of March 6th, only the fact that she was not in school.
Now, I'd like to talk about your second opinion regarding the events inside the victim's home on March 6, 2020. Did you review the prosecution's investigation?
If you want to call it an investigation, yes.
And do you agree with their findings?
No, I don't.
And what did you find?
Now, going through my own personal CSR, I discovered it's far more likely that Mackenzie Brackman was stabbed in the back, likely surprised by the intruder.
Before talking about your opinion, how did you reach your opinion?
Now, I went through all of the evidence that the prosecution provided me, as well as the coroner's report. And using those two together, I was able to make this counter theory.
Objection, Your Honor, this is outside of the scope of the witness's expertise.
Thoughts?
Your Honor, I do not believe that Professor Van Owen has testified as to any specifics regarding any information within or without of his expertise.
What do you anticipate him testifying to as a response to your question?
Your Honor, my question was simply, what did you do to reach your opinion? He did not actually make an opinion. I was simply asking the methods in which he arrived at his opinion.
Your Honor, response?
Yes.
As Mr. Van Owen has testified, he came to his conclusion through that autopsy, or excuse me, through the coroner's report, which does include medical opinions. And therefore, again, as I said, he is not, that is outside the scope of his expertise.
All right. Well, I'm going to overrule the objection. I'd like to hear what the witness is going to say about the methods he used to arrive at his opinion and what his opinion is. And we can certainly, you're certainly free to object in the future if you feel that's appropriate.
Thank you, Your Honor.
Overruled.
Professor, why do you disagree with the prosecution's investigation?
Now, mainly the scuffle, as well as the entrance of the intruder, indicate that a struggle did not occur. If we look at the evidence that the prosecution used to indicate a scuffle, it simply doesn't tell us anything.
Now, Professor, please turn your attention to what has been previously marked as Exhibit 12. Now, I'd like you to tell me when to pause the exhibit if you want to point anything out.
Okay. You could pause it right there.
Sure.
Yeah,
What did you find?
Now, here I'd like to note the baggy clothing that the perpetrator is wearing. Now, baggy clothing, it's my belief that the intruder brought a knife with them to the scene of the crime. Now, baggy clothing allows for weapons to be concealed within them. If you would resume the video. Now, as the perpetrator enters, you'll notice they close the door behind them and are met with no resistance as they walk into the house. Now, the scuff marks were created right inside of the door. Now, if the perpetrator was met with force, the scuff marks would make sense. That would be logical to assume a scuffle entailed. However, the scuff marks were, as they were right inside of the door, the perpetrator waltzes right into the kitchen. There's no indication that a scuffle did occur.
Professor, in your expert opinion, what do you believe happened?
Yes, I believe it far more likely that the perpetrator entered the home undetected and while inside stabbed Mr. Brackman from behind in the back.
Why do you believe this to be the case?
Well, I'd like to start as an investigator, not only myself, but Detective Markowitz, as well as Mr. Kyle Kuzak, rely on coroner's report. We rely on medical documents. Now, we might not be experts in the field of medicine. However, we know how to analyze these documents in light of an investigation. Now, with that being said, I relied on the coroner's report to give me insight as to what the knife and the insertion of the wound could tell me about how the crime occurred.
Using the coroner's report and the evidence at the crime scene, what do you believe happened?
Now, with that being said, the way the knife was inserted. Now, Mr. Kuzak explains this as a bear hug type manner. Now, I'd like to note that the knife was entered at a very straight angle. Now, why does that matter? So if the knife was entered at a straight angle, it disproves the bear hug theory. A bear hug would require the wrists to be inverted, which doesn't allow the knife to be entered straight. Now, if someone was to come from behind, the insertion would be directly from behind, allowing for the knife to enter straight in to the person, to Mr. Brackman's back.
Objection, Your Honor. This is once again outside of the scope of this witness's expertise.
Response?
Yes, Your Honor. Pursuant to Rule 702, Professor Van Owen has been tendered as an expert witness. Additionally, in the areas of crime scene reconstruction, given that Ms. Kuzak additionally testified to the direction of force of the knife and the mechanism of injury, this is certainly within the expert's expertise. Additionally, pursuant to Rule 703, Professor Van Owen may use coroner's report or other inadmissible documents to form his own opinion.
Any reply?
Yes, Your Honor. In regards to the 703, this was available to Mr. Van Owen. However, once again, he is not able to testify to any medical opinions. This is clearly a medical opinion, as it is in regards to the angle at which the knife was inserted and removed from the body.
Your Honor, if I may?
No, that's all right. I think that the opinion of the witness is not the it's not about the angle of the way that the knife was inserted, right? The witness has attributed that to the coroner's report without any further comment on it. So I don't find that this is outside the scope of this witness's expertise, and will overrule the objection.
Now, Professor, I'd like to move on to your third opinion, that the prosecution's investigation was faulty. Why do you think so? Why do you think this opinion?
There's three main glaring things that I saw when going through my investigation. To start, the prosecution honed in on a single suspect. They failed to investigate anyone else for the crime. Second, the prosecution relied on questionable evidence in their main theory, those being the text messages. And finally, the prosecution's investigators lost evidence.
Now, let's first talk about those text messages. What messages are you referring to?
Now, you saw, I believe it was Exhibit 14 earlier. These were text messages that were sent by supposedly sent by Miss Avery Becker to Alex Fuentes. Now, Detective Markowitz claims to be an expert in cell data recovery and cell phone tower data. Now, with that being said, Detective Markowitz holds an expertise in these fields and has received training on how to recover data from cell phones. So Detective Markowitz failed to recover this data himself. In addition, he could have easily recovered the phone if asked. So we don't know, because Detective Markowitz failed to gather the phone directly. We don't know whether these screenshots are reliable.
And briefly, you also mentioned lost pictures. What are you talking about?
The prosecution lost images of blood splatter. Whether these were important or not, I couldn't tell you personally. However, I believe that losing pieces of evidence goes more to show the quality of the investigation. It shows it was rushed, sloppy, and it lacked care from the investigators.
Now, finally, did the prosecution in your investigation investigate any other suspects?
No, they didn't. They honed in on one single person, a high school student. All right. They came into this case knowing that Mr. Brackman was a criminal defense attorney. Now, instead of seeking that path and thinking maybe it was possibly a past client who was unhappy or was convicted of something, they assumed it was a high school student. It's as if Detective Markowitz was in the middle of a field in Wyoming and he hears hoofbeats and he thinks to himself, must be zebras.
Briefly, Professor, you heard the Exhibit 22 played today. Why does that have basis in today's case?
That was Jonathan Rollins speaking out to Mackenzie Brackman, threatening him. Blair Rollins, his son, was present at the trial, heard this claim, and likely took it to heart, making him a potential suspect. But we won't know if he was responsible or not because no investigation was made in that direction.
Thank you, Your Honor. I have no further questions.
All right, cross-examination.
Thank you, Your Honor. Mr. Van Owen, you used to be a member of the Aurora Police Department, correct?
Yes.
But now you don't currently work there.
No, I am a PI as well as a professor.
And so now you work as an expert witness in trials such as these.
Yes.
But you mentioned in your witness statement that you have never testified for the prosecution, correct?
And yes, I'd be glad to explain why.
Because the prosecution does not pay for their witnesses.
No, that's not quite true. Although that is partially true, the prosecution doesn't need to pay for the witnesses. They have the police officers as well as the police's consultants to testify for them for free, whereas the defense has no one of that such nature.
Right, but they are not getting paid specifically to testify as you are, correct?
No, that's part of their job. I don't know exactly whether they're paid by the police department, but they're not being paid, I don't believe.
Right. And Mr. Van Owen, in your review of this case, you talked to Avery Becker, correct?
Yes, I did.
And you also talked to Taylor Perkins.
Yes.
But you didn't talk to anyone else, did you?
I attempted to talk to Alex Fuentes, but I was refused. Every question I asked was avoided, so it was not allowed for me to do so.
And you didn't talk to Detective Markowitz?
The detectives tend not to talk to PIs like me. They
Nor
don't
did you
really
talk
like
to
how I
Ms.
shoot down their theories.
Nor did you talk to Ms. Kuzak, did you, Mr. Van Owen?
No.
Yet, you critique the way in which the police conducted their investigation, correct?
Yes,
You say that it was rushed.
it was.
You say that the police chose their witness.
It's quite obvious, yes.
Mr. Van Owen, did you ever go to the crime scene?
By the time I became involved in the case, the crime scene had been cleaned up. So no.
Did you ever physically handle any of the evidence?
I think you're misunderstanding what it means to be a private investigator. Now, the nature of private investigation is to investigate the work of the prosecution's investigators. With that being said, you're pertained to images and evidence provided by the prosecution itself. So no, to answer your question, I was not able to go to the crime scene and witness it for myself. I was pertained to the images and pieces of evidence provided by the prosecution.
You just said that your job as a private investigator is to investigate the investigation, correct?
As well as provide logical theories as to what could have happened when the investigation is so flawed as it is today.
That's a yes, correct?
Yes, that is part of the job.
And let me emphasize again, you have not spoken to either Ms. Kuzak nor Detective Markowitz.
Objection, Your Honor. Asked and answered.
Sustained.
I'd like to move on, Mr. Van Owen. In this case, you charge $225 per hour, correct?
And I apologize. If you could please call me professor. I've earned the title and would appreciate that respect.
Oh, I apologize. So you have a PhD then?
I have earned my master's and am a professor. Therefore, that title is something I've earned.
You are a professor, but you have not earned the title professor, correct?
I have.
You do not have a PhD, so you have not earned the title professor, correct?
I believe PhD is for a doctor. I'm not a doctor. I'm a professor. I'm a teacher.
I would like to continue with my line of questioning, Mr. Van Owen. For this case, you have been paid just under $7,000, right?
Yes.
Let the court judicially notice that the fact that 7,000 divided by 225 would mean that you worked just over 31 hours on this case, correct?
Yes.
Yeah, Mr.
Objection, Your Honor. If I may, I don't believe the court was allowed an opportunity to respond and an objection to be made.
Do you have an objection to the court taking notice of that math?
No, Your Honor. I would just like the opportunity to object.
Are you objecting?
No, Your Honor.
All right. Please proceed.
Thank you, Your Honor. Mr. Van Owen, you still believe that the police chose their suspect despite you only interviewing 2 of the other witnesses on the defense, yes?
That was because I was unable to interview the others.
So that's a yes.
Yes, that's true.
And you still believe that the investigation was conducted unprofessionally despite, again, never having stepped foot on the crime scene?
Yes, it was.
And you still believe that the investigation was conducted unprofessionally despite, again, never talking to the other 2 people that were in fact investigating the crime scene, correct?
Objection, Your Honor. Asked and answered again.
Overruled.
And I'd like to back up a little bit and expand. You talk about how Detective Markowitz and Ms. Kuzak made a number of assumptions in their investigations, correct?
Would you mind if I answer the question you just asked me? In regards to, you don't interview other investigators. Mr. Kuzak doesn't interview me, and Ms. Kuzak, my apologies, doesn't interview me, and I don't interview her. That's simply not how it works.
I would like to move on, Mr. Van Owen.
Professor.
In your statement, you mentioned a student named Blair Rollins, correct?
Yes.
And referencing the audio recording that we listened to earlier today, it says that I will get back at you, correct?
It says, I'll get you back, Brackman, if it's the last thing I do.
Right. And in your witness statement, you say that, quote, Jonathan Rollins yelled out that Brackman was going to die, end quote, correct?
It was a threat, yes.
And you signed that witness statement.
Yes, I did.
And you signed that witness statement knowing that if there was any incorrect information, you would update that statement?
Excuse me, Your Honor. I believe that the prosecution is out of time for cross-examination.
Yes, I'll have the witness answer this question.
Sorry, could you ask that question again? I apologize.
You signed that witness statement knowing that if there was any incorrect information, you would update that statement, correct?
Yes.
Thank you, Your Honor. Thank you, Mr. Van Owen. I have no further questions.
Can you redirect?
No, Your Honor.
All right, this witness may step down. Are there any other witnesses the defense wishes to call?
No, Your Honor. At this time, the defense rests.
All right. Then the court is going to constructively read jury instructions to the jury, and then we will be ready to proceed with closing argument for the prosecution.
Your Honor, I ask that any time left over at the end of my closing argument be saved for rebuttal.
It will be.
May I proceed?
Whenever you're ready.
Ladies and gentlemen of the jury, do you know what happens when an unstoppable force meets an immovable object? Felony murder, that's what happens. Avery Becker, a high school kid whose idea of self-entitlement truly was unstoppable, met Mackenzie Brackman, a classic coach, determined to help his students his way. But why was Becker unstoppable? She's never really thought of herself as someone that society's limits apply to. From preparing for practice to listening to the advice of others, she's always just done what she pleases. In mock trial practice, she believed she didn't need to prepare to remain focused. Why would she? After all, she was the best attorney at regionals. So why should she have to do what the other kids do? Why should she have to follow the rules? when she can just make it up on the spot and do better than them. After all, because she's so good at mock trial, she thinks she deserves to play by her rules. It doesn't matter what everyone else does, as long as she gets her way. All of this against the immovable object, Brackman. Deeply rooted in his ways, he was fully committed to helping his students the only way he knew how, and fully committed to being the best coach he could be. He always believed that if Avery was to truly be successful, she would need to learn how to work hard and prepare. So he tried to instill in her the best work ethic that he could, but she just wouldn't listen. Now, there are two charges brought before you today that you must find Avery Becker guilty of. The first, felony murder, charges Becker with unlawfully and feloniously committing or attempting to commit second-degree burglary and in doing so killing Mackenzie Brackman. The second, second-degree burglary, charges Becker with unlawfully and knowingly entering and remaining in Mackenzie Brackman's residence. Let's start with second-degree burglary. Jury instruction number 8 charges Becker with entering Mackenzie Brackman's residence with the intent to commit criminal mischief. Both Detective Jordan Markowitz and Alex Cifuentes proved this to be true. Detective Markowitz proved it by showing you text messages exchanged between Avery Becker and Alex Cifuentes, where Becker told Cifuentes that she was going to trash Brackman's house. Cifuentes proved it by testifying that Becker was angry after being kicked off the mock trial team and wanted to get back at Brackman for what he had done. Detective Markowitz also used her expert knowledge of call detail records to corroborate the fact that Becker's phone, which had apparently been stolen, was in the vicinity of Brackman's house at the time of the murder. Detective Markowitz and Alex Cifuentes' testimonies have clearly proved that Avery Becker was at Mackenzie Brackman's house with the intent to commit criminal mischief, and he is thus worthy of a second-degree burglary conviction. Now on to felony murder. Jury instruction number 10 charges Becker with killing Mackenzie Brackman while committing second-degree burglary. Crime scene reconstruction expert Kyle Kuzak outlined the details of her investigation and recreation of the crime scene to you. She observed evidence like the broken plate and missing knife from the knife block to conclude that based on signs of a struggle, Mackenzie Brackman had interrupted a burglary and gotten fatally stabbed. Detective Markowitz and Alex Cifuentes proved to you that Becker was committing second-degree burglary, and Kyle Kuzak proved that Becker killed Brackman in the residence. Both counts of Avery Becker's charges have been proven to you. Now, ladies and gentlemen of the jury, as you listen to the defense's closing argument, please keep one thing in mind. Avery Becker did what she thought she deserved. If she was the best person at mock trial on her team, she deserved to not prepare. If Mackenzie Brackman insulted her after winning a big award at regionals, she thought she deserved to trash his car. And if Brackman kicked her off the mock trial team and ruined her mock trial career, she thought she deserved vengeance. Jury instruction number 2 states that if you find from the evidence that each and every element of a crime has been proven beyond a reasonable doubt, you must find the defendant guilty of that crime. The prosecution has clearly proven all elements of Avery Becker's charges beyond reasonable doubt, so you must find her guilty. Thank you.
Thank you, counsel. Does the defense have a closing argument?
Yes, Your Honor. Members of the jury, I'd like to simplify the prosecution's arguments that you just heard. You just heard a story about a high school girl who was apparently so upset over an extracurricular activity that she killed her coach. That is all the prosecution has. And as a result of a rushed investigation, they're willing to put her in jail for the rest of her life. Now, you heard that Ms. Becker and Mr. Brackman didn't have the best of relationships, that after she won 2 regional awards, she was demoted to the B team. In a moment of weakness, she rode on his car. Now, does that warrant a conviction of murder without a solitary eyewitness and mere circumstantial evidence? Well, for the prosecution, it does. Now, you just heard the prosecution make some speculative claims about the events of March 6th, and I'd like to talk about them. The prosecution wants you to believe that on March 6, 2020, Ms. Becker was so upset about mock trial that she attained the address of her coach and drove to his house to vandalize it. They want you to believe that once trying the front door, she moved around to the back. They want you to believe that Mr. Brackman received a notification on his phone, and instead of calling 911 or running out the front door, he armed himself with a knife. Then the prosecution wants you to believe that Ms. Becker didn't see her coach armed with a knife inside a glass door. Then they want you to believe that Ms. Becker and Mr. Brackman had some sort of scuffle. Then they want you to believe that Ms. Becker, a high school girl, got the knife from her middle-aged male attorney coach and stabbed him in the back. Ms. Cusack wants you to believe that once Ms. Becker fled the scene, Mr. Brackman was left to pull the knife out of his own back, and then he died. Ladies and gentlemen, that is what you heard. And it's also what Professor Van Owen was presented with. As you heard, Professor Van Owen saw the inconsistencies within the prosecution's case. He outlined how cell tower data is not helpful for pinpointing the location of a phone, and even if it did, it would only put Ms. Becker's phone at the scene of the crime, wouldn't put her there. He also noted that Detective Markowitz failed to get Mr. Brackman's phone, which would have shown us if he received that alert on his phone or not. Additionally, Detective Markowitz didn't deem it necessary to ask for Ms. Cifuentes' phone. Instead, she was fine with screenshots that could have been faked or created. You heard Ms. Cifuentes admit today that she was on Ms. Becker's phone on the day before March 5th, 2020. Additionally, you heard Ms. Becker say that she had never seen those texts before in Exhibit 14. Additionally, Detective Markowitz and Kyle Cusack both lost the same pieces of evidence, which would provide a clear picture as to where Mr. Brackman was stabbed. This would have told us if Mr. Brackman was stabbed while he was unaware at the table, or if he was stabbed in a struggle, like Ms. Cusack said. Now, were these images contrary to the prosecution's case, or were they left out because they were lost? We just don't know. Additionally, we even heard that Detective Markowitz even moved Mr. Brackman between taking pictures of evidence. Now, every piece of evidence that you were presented today by the prosecution was done so in a selective manner. The prosecution knows that cell towers aren't helpful for pinpointing a location, but they didn't tell you that. They know there's another suspect, Blair Rollins, who had a reason to kill Mr. Brackman, but they left that out of their case. Instead, members of the jury, Detective Markowitz, Ms. Cusack, and the prosecution pushed their own narrative and made a complete mockery of justice. Detective Markowitz didn't have to make herself an immovable object, but when she ignored additional evidence and ignored additional suspects, she chose to. Prosecution holds the burden of proof. They must prove beyond a reasonable doubt that Ms. Becker was the killer. So ask yourself, do you have any doubts that Ms. Becker was actually the killer? Now, we don't know who went into Mr. Brackman's house, and we don't know who killed him. But what we do know is it was not this high schooler. Stop this mockery of justice. Thank you.
Thank you, counsel. Any rebuttal?
Yes, Your Honor, I request a time check for how much time I have for the rebuttal.
All right, go ahead. There's a timekeeper on who can.
Ladies and gentlemen of the jury, I would like you to remember that detective experts like Detective Markowitz and Kyle Cusack based their opinions off of facts and data made available to them, opinions that they are fully entitled to form based on their occupation. Do not let opposing counsel belittle the work of the experts in this case or belittle their civic duty. Thank you.
All right, thank you. All right. Okay. Well, if we were in a real courtroom, we'd all give you an ovation here. So unfortunately, we can't do that. But I think what should probably happen now is for the scoring panelists to finish entering in their scores and submitting their score sheets. What would probably be best is if they wanted to keep their cameras off until they submit and then turn them on and we'll know they're done. And then, okay, it looks like 2 of you are already done, maybe. Cool. Okay. Well, I just want to thank both teams for a wonderful experience for us to have been judging today. You all were absolutely terrific. This was a really good round. I'm sure you're all aware. And I just really want to thank you for your preparation and your preparedness and how well you presented your cases. It was really a treat to watch. So I hope you're proud of yourselves and what you've accomplished in this tournament. And I'll turn it over to the scorers if they have any comments they want to share. And Ms. Grote, there you go.
Yes, I just, sorry, couldn't get my mouse in the right place. I just want to say that it's clear to me why both teams are in the 4th round. You did an excellent job. Some of the attorneys on cross were just brutal. And the witnesses held up well. Opens and close were fabulous. Best of luck to all of you. And I hope that you really, I appreciate how much work you put into this. And I hope that you express appreciation as well to your parents, family members, and coaches, because we are all invested in this, in, just helping you be a success. And you're helping other people be a success as well.
Hi, this is Brenda Young. I am so impressed, and I was really happy to see that none of this seemed like it was scripted. Everything seemed so real and believable, and the passion that was put into all of the questioning and defense, everything was so exciting for me to see. And I hope you're as proud of yourselves as we are of you, because this is incredible. You did a fantastic job. And I was really happy to see the use of your hands and the expressions on your face, and you could see the passion behind your words, and that's so important. So I wish you all the luck in the world, and I'm really happy that I could be a part of this.
I guess I'll go next. So I agree with Mary Jo with the cross-examinations were really well done. It was a very good job of trying to control your witnesses. A lot of the thank you, but my question was this and things like that. Controlling a witness is hard to do on cross-examination. You guys did a very good job trying to control the witnesses. I thought the direct examinations were really well done as well. I really liked it when you got a no from one of your questions. So you'd ask a question, then the person would say no, and then correct you as far as what their response was. It made it feel like it was a genuine answer. Witnesses were doing pretty well. It's hard for me to judge witnesses because it's a bit of acting as well. But I thought they did really well. I think they were very knowledgeable, and everyone was clearly very well prepared for a series of questions, and even the minute details they knew pretty well. Opening and closing, thank you for mentioning the burden of proof. and who has it and why they have it, and that it's a difficult burden and why it's a difficult burden, as well as, hey, we met this difficult burden. You didn't shy away from it. A lot of times when you do a closing argument and you have the burden of proof and it's a difficult burden, you want to shy away from that. But you guys didn't. You guys took it dead on, which is very difficult to do, and it's a very good thing that you guys did that. Oh, and you guys are very knowledgeable as far as responding to objections and what the laws are as far as the rules of evidence throughout. So that was very impressive to see. So I think those are my comments generally.
And I just would like to say that you did a great job of setting your themes and making sure that you're following those themes throughout, calling out within your direct and crosses, especially reacting to one another's themes, predicting and reacting to them. So I liked seeing that. And pretty much you all have been doing it so long that it's pretty smooth, and you know what you're doing and reacting and thinking of new ways to get at the other side, while still maintaining your point of what you were doing. So
Yeah, it's a good job, everybody. We'll let you all relax now after your final round. Take care.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you.